ಹಲೋ ಸರ್, ವಾಯ್ಸ್ ಮತ್ತೆ ವಿಡಿಯೋ ಕ್ಲಿಯರ್ ಇದೆಯಾ? ಹಲೋ,
ಕ್ಲಿಯರ್ ಇದೆ, ಕ್ಲಿಯರ್ ಇದೆ.
ಥ್ಯಾಂಕ್ ಯು ಸರ್. ಸರ್, NGR ಲಾ ಅಸೋಸಿಯೇಟ್ಸ್ ಇಬ್ಬರು ಕನೆಕ್ಟ್ ಆಗಿದೆ, ಒಬ್ಬರು ಡಿಸ್ಕನೆಕ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್.
ಎಸ್ ಸರ್, ಎಸ್ ಸರ್, ಮಾಡ್ತೀನಿ ಸರ್, ಮಾಡ್ತೀನಿ ಸರ್.
ಥ್ಯಾಂಕ್ ಯು.
ಮೊಬೈಲ್ ಇದಿಲ್ಲಲ್ಲ. ಡೋರ್ ಹರಾಸ್ಮೆಂಟ್ ಕೇಸ್ ಹಾಕಿದ್ರ ನಿನ್ ಮೇಲೆ? ವರದಕ್ಷಿಣೆ ಕಿರುಕುಳ ಕೇಸ್ ಹಾಕಿದ್ರ?
ಹಾಕಿ ಅದು ನಾವು ಇಷ್ಟೇ ತಗೊಂಡಿದ್ವಿ. ಅವ್ರು ಹಾಕ್ತೀನಿ ಅಂತ ಅಂದಿದ್ರೆ ಅವಾಗ ನಾವು ಇಷ್ಟೇ ತಗೊಂಡಿದ್ವಿ.
ಬರ್ತಾನೆ ವಯಸ್ಸು. ಮಾಡಿಲ್ವಾ ಮುಟೆಡ್
ಕೇಳಿಸ್ತಾ ಇತ್ತು ನಾವು ಮಾತಾಡೋದು ಅದ್ಯಾವುದೋ
Yes.
Manoj, may I mention a matter?
Sir, the Learned Counsel for the appellant submits that the copy of IA 1 of 21, 2 of 21, and 3 of 21 has already been supplied. Learned Counsel for the last of respondent number 1. What do you want? Learned Counsel for respondent. Learned Counsel for respondent prays for 2 weeks time to enable him to file objection. Yes.
Manoj, may I mention?
Yes. One
Please,
minute.
Manoj.
Some lawyer
Please,
is
please,
waiting.
Manoj.
Impatient.
Please, Manoj. No, Manoj. Manoj, I could not hear Manoj. My sincere apologies, Manoj.
You are appearing from Delhi, right?
Yes, Manoj. I'm so sorry,
See,
Manoj. Manoj,
how we know? How we know? I mean, you without telling us that. So,
Manoj, sincerest apologies, Manoj.
what do you want?
Sincerest apologies. Manoj, I appear for the appellant in item 28. Manoj, due to some personal...
We don't adjourn the cases out of turn at 10:30. You should know.
Please, Manoj, I will appear at my...
Appearing. We don't have in. This has been my practice, and we have been following it up throughout. Now,
Manoj, I'll appear at
13 years. We don't appreciate this practice of 10:30 adjournment.
Sincerest apologies, Manoj.
We will take care of our case. Don't worry. Don't appear.
Sincerest apologies,
Nobody is compelling you to appear. Yes.
In serial number 2, Manoj, in serial number 2, I appear for respondent number 3.
No adjournment.
No, not in adjournment. Serial number 2 is going on.
Achha, you are appearing.
I appear for respondent 3 and 4 in the matter, my lord.
So what do you want?
My lord, it's for the appellant to comply with office objections, my lord. They have not complied.
Let him comply. Yes. 2 weeks peremptory. What office objection, mister? Office objection 1 and 2 counsel submission is 2 weeks, right? 2 weeks.
The government has passed it. It is in respect of the institutions which are shifted. Saying that there are new institutions.
No. So what it has, no infructuous. What do you want to say? Then what do you?
The applicant, to consider our claims in accordance with what the.
Which government order?
We consider that government order. Do you know anything about that government order?
They don't know the government order. How it is easy for you to say, I don't know. Complete ignorance, the best thing in the world. We also don't know anything about the case. Now, who will pass an order now? You don't know. We also don't know. He also doesn't know. So what will happen to the litigant?
Give me a copy.
List for orders on admission in next week's time. Don't say anything. List for orders on admission in the next. It's not a good thing to say, I don't know. We can take you to task for making a statement. How do you, we will ask the government, how do you appoint the councils who do not know anything? We will ask don't Mr. take it lightly. Don't take it lightly standing up like this. We will ask the state government, how have you engaged a council who doesn't know? And we will ask Advocate General also that he has the guts to say that he does not know about the government order and doesn't know anything about the case. What basis you have been appointed? This is your efficiency level. We are seeing every day. We don't say anything to you. So day by day, you are being emboldened. You are emboldened even to say that I don't know about the government order. I don't know about the case. Then why are you here? Get out. No, get out then. Don't appear. We do not like councils who do not know anything about the case and do not know about the order. So this is what you said, right? You said, I don't know. No, can you, being a government advocate, can you say that I do not know? Tell us. Can you say, I do not know? Yes. Weeks preemptory. Memo of retirement has been filed by learned counsel for the appellant, which is accepted, and the appellant is permitted to retire. The appeal is dismissed to notice. Oh, he has already said appeal is dismissed for want of process.
My lord, in serial number 5, I appear for respondent number 3 and 4, my lord.
Non-compliance of office objection. Notice has been issued. Who appears for impleading? Any objection to impleading application? Heard on IA learned counsel for impleading applicants. No, learned counsel for respondent submits that he has no objection to IA 1 of 22 being allowed in view of opposite submission and for the reasons assigned in the application, duly supported by an affidavit. IA 1 of 22 is allowed. Amended cost title will be filed within a week. Interim order. The patent on earlier occasion shall continue, right?
Grateful, my lord.
So, but it should continue, right?
Grateful.
That was a mistake. IA 2 of 22 is accordingly allowed, right? Interim order shall continue. IA 2 of 22 is allowed.
Grateful.
Learned counsel for the appellant praise for and is granted 2 weeks time to enable him to take steps for substitution of LRs of disease respondent. 3. Respond number.
Grateful, my lord.
Hey, why are you grateful? He is appearing. Yes. So somebody on the screen is saying grateful. You are appearing, right? For the applicant.
Next respondent.
Respond number 3.
I respond for 3 and 4, my lord.
Okay.
I am for response
Yes.
4.
Yes. Learned counsel for the applicant has, you have filed a memo seeking leave of this court to retire. He is permitted to retire.
New counsel, Shashidhar.
R. Shashidhar has filed. You can write learned counsel for Mr. R. Shashidhar. Learned counsel has filed a memo seeking leave of the court to withdraw. Retire from the case. He is permitted to do so. Memo is accepted. Let appeal is admitted. No. Appeal is admitted for hearing. Record. A memo has been filed seeking next 7. A memo has been filed seeking leave of the court to withdraw the appeal. The aforesaid memo is taken on record. Accordingly, appeal is dismissed as withdrawn. Seeks leave of this court to withdraw the appeal with the liberty to file an appeal under the appropriate provision of law. So we are granting you to file an appeal under appropriate provision. But he says, see, memo of withdrawal of appeal.
Liberty to file a fresh petition.
Yeah, we don't know. Separate cause of action. You can always file. Same cause of action we cannot permit. Law prohibits. You understand, right? How can we pass an order contrary to law? Can law permits? So that's why. Whatever it is. Has filed a memo seeking leave of the court to withdraw the appeal. The aforesaid memo is taken on record. The appeal is dismissed as withdrawn. How much time? How much will you do when you? Yes. So she must be her parents. Parents. Section 9 of Hindu Marriage Act. Restitution of conjugal rights, not habeas corpus. No, Mr. This is a misuse of process of law, and we should perhaps, it is high time when we should start imposing costs. High time. This is obviously a case of a matrimonial dispute. Your wife leaves you and goes away and is saying, and you have filed a writ of habeas corpus. Under whose illegal detention she is? Tell us. No, tell us from cost writing. Who has illegally detained her against her wishes? That person is not a party. This in a matrimonial dispute, you will file habeas corpus. Fine. No, he is only, we are hearing him because he has to pay costs. That's why we are hearing him. Yes. Your wife is appearing through video conference. We can see her. Mr. How much? What do you do, Mr.? What do you do? What is your client doing? What? Business. So how much cost will you pay? He appears to be a rich man, wealthy. 50,000 rupees minimum you should pay. No, this is abuse of process. Abuse. So tell us, you see who has detained your wife? Who has illegally detained your wife? Who has detained? Now, are you not required to implead that person? Mister, we are not sitting here to teach you the law of preventive detention, right? This petition has been filed by the husband seeking a writ of habeas corpus for production of what's the name, Mister? Protection of one Reshma. The petitioner claims that aforesaid Reshma is his wife. Paragraph. Learned additional government advocate, learned SPP or SCGP. After instructions states this court that the wife that Reshma, aforesaid Reshma, does not want to stay with the petitioner. In her statement, she has further stated that she does not she has not been detained against her wishes by anyone. Full stop. Even otherwise, the petitioner has not impleaded anyone who has allegedly detained Srimati whatever Reshma against her wishes. Full stop. She has appeared, right? She is appearing. Srimati aforesaid Reshma has appeared through video conferencing and has stated that she does not want to stay with the petitioner. For the aforementioned reasons, we do not find any merit in this petition. The same is thoroughly misconceived and is dismissed. Plea hearings got admitted, Mr. Heard on IA, December, January. Tell us date in January, heard on IA 1 of 21, taking into account the fact that appeal is since 2015, IA 1 of 21 is allowed. Let the appeal be listed for final hearing on 10th January 23.
Appeal for the appellant, the delay of 41 days.
Heard on IA 1 of 2018. After hearing learned counsel for the parties and for the reasons assigned in the application, duly supported by an affidavit, delay of 41 days in filing the appeal is condoned. In the result, IA 1 of 2018 is allowed.
Not as admitted, Mara. It just be posted.
Appeal is admitted for hearing.
Yes, Mara.
Record. Heard on IA 2 of 1 of 20 for the reasons assigned in the application, duly supported by an affidavit, delay of 2 days in filing the appeal is condoned. In the result, IA is allowed. Appeal is admitted for hearing. Record. What state? Issue notice. No, don't say. Notice is already issued. Yes.
For admission, number 12.
Admit. Appeal is admitted for hearing. Record. Infructuous. Acha. Learned counsel for the appellant submits that the minor daughter of the appellant during the pendency of the appeal has attained majority. Therefore, nothing survives for adjudication in this appeal. Line below, accordingly, the appeal is dismissed. Admitted for hearing. Record.
Number 40.
Appeal is admitted for hearing. Record. What state? Resolution. In the heard on IA 2 of 2015. In the meanwhile, operation in effect of impugned judgment and decree insofar as it pertains to dissolution of marriage shall remain stay. All right. Delete that. Heard on IA 2 of 2018. learned counsel for respondent. When she learned counsel for respondent submits that respondent has remarried on in August or September 2018. In the aforesaid submission is placed on record. IA2 of 2018 is disposed of. Appeal is
I have to
at
respond to this matter, my lord.
record. What? Yes. Maintenance.
Maintaining the sense, my lord. They already petition filed the CMS before the JMF said Gubbi, my lord. The order, the IAS maintenance is hard passed, my lord. They filed an application here for seeking the maintenance, my lord.
Huh? How much was granted by the this thing family court? Huh? 10,000. Yes. Is it correct? 10,000.
No, my lord, it is 8,000, my lord.
8,000. So then you have
8,000
to
is passed,
pay.
my lord. But the thing is, my lord, they have filed a separate petition before the JMF said Gubbi, my lord.
No, that they can file. Under different provisions, they can claim maintenance, right?
No, my lord, they are seeking the monthly maintenance, my lord.
How much they have granted? How much they have granted before JMFC?
It is 6,500, my lord.
Very good. Ask the questions.
In the CMS number 105 of 2020, my lord, they filed the CMS petition in the year of 2020, my lord, after filing of the MFA. They filed the CMS, my lord, separate maintenance petition. As per the maintenance petition, they pass an extraordinary order.
Ask him which 125. 125 CRPC, you are the Mr.
For the JMFC, how much you have been awarded, Mr.?
Six 6,500, my lord.
He was awarded 8,000.
This petition is pending before the JMFC, my lord.
1,005. 2,000.
Ile start ಮಾಡಿದ್ದು.
Yes.
Chicken Gowder, you have been awarded 6,500 before the JMFC. Uh, 8,000 it has been made. 8,000. What is your claim here? What is the respondent doing?
He is in daily basis labor, my lord. He is living with his old age mother, my lord. She is an 85-year-old, my lord.
Wife has filed IA number 1 of 2018. Paying maintenance of rupees 20,000 per month. For herself and her minor son Vaibhav. And also has litigation and expenses at the rate of 50,000 from the respondent. Counsel is appearing for the appellant as well as the respondent. Submit that he and the minor son have been granted maintenance amount of $50,000 per month. That is 4. WP number? 2016. He has been paying that regularly. He has been paying that. And the respondent has been paying the such amount. Considering this submission, in addition to the aforesaid amount of 8,000 granted by this 14 WC number 7. So we need to direct the respondent to grant the sum of the additional sum of rupees 2,000 per month. Appellant, the minor son of application. Further direct the respondent to pay a sum of 10,000 to the appellant towards litigation expenses.
Milord,
And the aforesaid sum of 10,000 towards litigation expenses shall be paid in the period of 4 weeks from the date of application. Per month from the date of work.
no, Milord, 10,000 is Milord. He is in daily wage labor, Milord. He has looked at his old age mother, Milord.
1,000 is towards litigation expense, Mr. Not per
Milord.
month.
IA is allowed, 1 of 18.
10,000
These are the advantages of appearing through video conferencing, right? These
Sorry,
are the
madam.
advantages. Enjoy. Yes.
No, Milord. No, Milord.
Enjoy the comfort of your office. Be happy.
No,
Yes.
no, I'm extremely sorry, Milord. The personal inconvenience.
No inconvenience. Order passed. Yes. Huh? LCR. Office is directed to secure records of family. The beginning you write. Then heard on IA, 1 of 8. Yes, madam. Whose instruction? Why will we instruct? I am not the appellant. Why will we instruct? Huh? No instruction. Who has given when? Instruction. We don't give instruction to your parties, right? You can give. Who has given instruction when? What? Huh? Huh? No. Perhaps you are laboring under some sort of a misconception. No instruction has been issued to you by this court. Which instruction? Huh? No, but who has instructed you? We have not instructed anyone. It's not our appeal, madam. I have not filed an appeal, so why I will instruct anyone? Nobody has instructed anyone. Which tell us which we speak only through our orders. Huh? No. Which order? Which state? Why will we instruct? It's your application. You are contesting the appeal. Why will we instruct you? What application? Madam, your appeal is listed for orders on admission. It is not, you don't know. We are sorry to say that you do not even know that delay has already been condoned and nobody has instructed you to file an affidavit. This is the state of affairs. Why do you come to court? Why? You are absolutely non-serious about the whole thing. It is listed for orders on admission. You are telling us that we have instructed you to file an application, whatever additional. Why will we instruct? We are not appellants, number one. Secondly, appeal is listed for orders on admission. You argue enough of adjournment. Yes. No. Why no? This is for admission, madam. This is making incorrect submissions. Factual submission is not means you don't even see the cause list, let alone the file. What purpose the case is listed? No, we asked you why the appeal is listed today. This case, what? No, who instructed? Is what nobody's instruction, neither our instruction nor your instruction will prevail. What is there in the call list? This is WA 10 of 2019. It is listed for admission along with orders on additional affidavit. It has been condoned.
Date of hearing between and if you want to file the
Argue on admission matter. Yes. Like, yes. Order sheet indicates that delay in filing the appeal has already been condoned by an order dated 22/9/2020-22. Therefore, no further orders are required to be passed on additional affidavit which has been filed by the appellant. Learned counsel, when this court asks learned counsel for the appellant to argue the matter on admission, she prays for adjournment. List in the next. Don't come back to this court. We don't like such tactics, right? See, it shows that absolutely no resistance from the bar. You have a responsibility.
properly instruct the junior court here.
The papers, you can make out that they are just going through here. Had I known that practice is so easy, I would have never become a judge. See how he's talking. Yes. Huh? Huh? Why? Huh? How many adjournments missed? On the ground that charges are vague. It's not vague. Where are the charges? What happens to him? Council is out of station. Appeal as well as the cross objection is heard on IA 1 of 2019. An application seeking condonation delay of 105 days in filing the appeal. After hearing learned counsel for the parties, we find that sufficient cause for condonation delay of 105 days in filing the appeal is condoned. In the result, IA is allowed. It is admitted for hearing. Cross objection also you write. Cross objection heard on IA 2 of 2022. After hearing learned counsel for the parties, delay of 175 days in filing the cross objection is condoned. In result, IA 2 of 22 is allowed. Cross objection is admitted for hearing. And then before that, admitted for hearing, you write heard on IA 1 of 22 for reasons assigned in the application, requirement of filing the production of writ petition papers and statement of objections is dispensed with. Accordingly, IA is allowed, then cross objection is admitted. Permission to prosecute the appeal. This has not been heard. Issue. All right. Yes, Mr. No. Huh? That's the point. Nothing to say. This is the observation. Oh. All right, we'll allow this to the extent it directs. It has to be set aside. It's an interim order. Or, yes, mark the presence. So currently, learned senior counsel with so and so for the appellant, Mr. S.N. Bhatt, learned counsel for respond number 1, learned additional government advocate for 2 to 4. Third on IA 1 of 2019, since the appellant is a person aggrieved, he is permitted to prosecute the appeal. Accordingly, IA 1 of 2019 is allowed. Paragraph. This intra-court appeal has been filed against an order dated 17/7/2019 passed by learned single judge, by which learned single judge has directed that a criminal prosecution be launched against the appellant and after keeping him under suspension. After keeping him under suspension. Paragraph. Facts giving rise to filing of this appeal briefly stated that appellant at the relevant time was posted as Tehsildar of KR Puram Taluk. Full stop. The respondent number 1 filed a writ petition, namely WP number 2222 2019, in which he sought a direction to consider the representation dated 29/9/2018 submitted to the Assistant Commissioner and for transfer of revenue entries in respect of land bearing survey number 99 measuring 4 acres of 4 acres situated at Kaji Sonehalli village, Bidharhalli Hobli, Bangalore East Taluk. Page 125, it's all given. The paragraph, the appellant forwarded the matter to Special Deputy Commissioner for inquiry under Section 136(3) of the Karnataka Land Revenue Act. The Assistant Commissioner on 10/4/2018 issued an endorsement regarding the representation made by respondent number 1. However, the learned single judge, by impugned order, without affording an opportunity of hearing to the petitioner, directed that the appellant, that a criminal prosecution be lodged against the appellant and he be placed under suspension. Full stop. In the aforesaid factual background, this appeal has been filed. Paragraph, we have heard learned counsel for the parties at length. Admittedly, the impugned order has been passed. Admittedly, the appellant was not a party in the writ petition, and the impugned order has been passed without even issuing a notice to him or without affording him an opportunity of being heard. Full stop. Without affording an opportunity of being heard. The impugned opportunity of being heard. The impugned order is outside the scope of the writ petition. The same, for this reason also, the same cannot be sustained in the eye of law. It is accordingly quashed. In the result, the Appeal is allowed. Appeal is admitted for hearing record.
Number 20. Number 10.
Admitted for hearing. Same order, but admitted for hearing record. 20. Same order.
22. Prasanna here.
What? So what do you think is the order passed? Huh? Appeal is dismissed. What is the order which can be passed? Mr. We don't know why do you come to attend the hearing of MFA when the law provides that an appeal shall lie to the High Court. Appeal lies, right? So we have to admit, right? We cannot dismiss. What is there to argue? And you, what objection can you have? We do not need your no objection.
Just as that.
Fine, thank you. No, you are looking at us with curiously, so we thought that are we doing something which illegal or something? It's your appeal, right? Then it has been admitted.
Please.
Be happy. Not unhappy. Okay.
Said anything.
Fine, thank you. What? Admitted for hearing. What is it? What direction, Mr.? Why are you standing here? Respondent? Huh? Huh? Oh. Acha. Yes, 22. Admitted for hearing record. What is direction? So issue notice on IA 1 of 20. 1 of 20. Litigation expenses. Interim maintenance, Mr. So then they have been served with the notice. Nobody is appearing. What? How much was granted, Mr. by the family? No, what is he doing as respondent? Huh? Electrician. Para 3, electrician, 200 per day. You are saying jewelry shop.
You have paid some maintenance amount in the domestic violence.
No single time is paid.
Where have you said it in the application? The application seeking interim maintenance. Where have you said that it was paid and there was order that it was not paid?
Learned counsel for the appellant praise for is granted a week's time to enable it to file and support of IA 1 of 20. Better affidavit, right? 23. Appeal is admitted for hearing record.
Was complied.
So why have you not complied? Is there any stay? Oh. Appeal is admitted for hearing. 25. Oh, before that, you write 3 of 21. Huh? IA 3 of 21 reasons assigned in the application duly supported by an affidavit delay of 58 days in filing the appeal is continued. IA is allowed heard on the question of admission. Appeal is admitted for hearing. He's looking at you. What does it? We were trying to understand what does it signify. So, I mean, we thought that in preparation of making a prayer for adjournment, he's looking at you and trying to find out whether you will oppose if he makes a prayer. That's what he's trying to assess. Yeah, we don't know. We don't know what is it. Yes. Huh? Huh? Password. Password. Huh? Hey, don't, Mister, don't tell him. This is not the way. Don't tell him. This is not an inquiry counter. No. You argue, Mr. One argument is referred to be full bench. Fine. What is the second submission? Huh? Please make. What is it? 10 years delay. What is the explanation of 10 years delay? 28.1 and 28.4.
In the family, joint family, original suit was pending. And
There was an interim order of injunction. How are you concerned with their dispute in the family?
Before the interview to not to receive the compensation to the following hearing. We have elected all of them.
That's a different thing. Huh? So what is the explanation for not passing an award? Give that, Mr. Judgment. We have said no, even if no period of limitation is prescribed, it has to be done within reasonable time. Huh? Just 2-3 days ago only it was there. What is the reference to full bench? We don't think. What is the reference to full bench? What is the question referred? No, it can't be. Where is the order of reference? telling you an order of reference. See, you want us to refer this matter to full bench. And do you have the copy of order of reference? Just like casually, right? Walking in the, had I known, I mean, really, Mr. Counsel, we envy you. Had I known that practicing law is such an easy task, we would have never become judges, really. I could have never dreamt of appearing before a division bench and making a submission that it should be referred without citing the order of reference. You don't know and you are saying how? Where is that order of reference? We will dismiss it, your prayer only on this ground that you yourself don't know where is the order of reference. Then if you tell us that I should be given time, I have just like that. What is having? This is all because it is KIADB, right? So we will file SLP. No, because you have plenty of money. So we will file SLP, let the court decide. No, we will write about your conduct and ask from KIADB how they engage such counsel who do not know anything. Where is the order of reference? We are asking you. Where is the order? What has been referred? You just casually said, right, that it should be referred. Why? Because you want an adjournment. This is what. There is nothing to prepare and nothing to argue. Mr. 10 years delay in filing in not passing the award proceeding have been quashed. What will you what are you ready with? Tell us. What is there to argue? Mister. Wait. We are not asking you. Where is the order, Mister? Yesterday it was given, right? They will not give because. Yesterday, Mr. Dhan Chinappa gave. Yesterday it was listed.
With your lordship's kind indulgence, my sincere apologies.
No, nothing, no indulgence. Mr. B.B. Patil, learned counsel for the appellant. Which case? This is 26. Mr. B.B. Patil, learned counsel for the appellant. Heard on IA 3 of 21. Heard on IA 3 of 21.
KB Lingaraju's case.
Yes. Heard on IA number 3 of 21. For the results assigned in the application form, a requirement of filing the writ petition and type copy of annexures and color photographs is dispensed with. IA 1 of 21 is dismissed as withdrawn. Heard on the question of admission. This intra-court appeal has been filed against an order dated 24th of November 2020, passed by learned single judge. This intra-court appeal has been filed against an order dated 24th November 2020, passed by learned single judge, by which writ petition preferred by respondent number 1 has been allowed, and preliminary notification as well as final notification dated 7/5/2007 and 24/4/2007, 24/4/2010 have been quashed. Paragraph. Facts giving rise to filing of this appeal briefly stated are that respondent number 1 Details of land not given. Respondent number 1. Is owner of land.
Number 104.
Owner of land bearing survey number 104.
During 1 acre 7.
Measuring 1 acre and 17 guntas situated at Sunagadda village, Kundana, Hubli, Devanhalli, Taluk, Bangalore. Full stop. The respondent number 1 and her family members had constructed houses and houses by obtaining license and plan from Gram Panchayat, and they have also put up cattle sheds and residing there, residing on the scheduled land. Full stop. The Karnataka Industrial Areas Development Board issued a notification under section 13, and 31 of the Karnataka Industrial Areas Development Act, declaring the scheduled land as well as adjoining lands as an industrial area. Thereupon, paragraph. Thereafter, a preliminary notification dated 7/5/2007 was issued. Thereafter, a final notification under section 28 within bracket 4 of the Act was issued on 24/4/2010. Full stop. However, despite a period, no further action in the matter was taken. Neither any further action in the matter was taken, nor the proceeding initiated for acquisition of land were concluded. Full stop. The respondent number 1, paragraph. The respondent number 1 challenged the validity of the acquisition proceedings in a writ petition before the learned single judge. The learned single judge, by an order dated 24th November 2020, inter alia held that despite a lapse of 10 years, from the issuance of notification under section 28 within bracket 4 of the Act, the award has not been passed. Full stop. The land acquisition, the learned single judge therefore held that the proceedings have lapsed, and accordingly the same were quashed insofar as it pertains to land held by respondent number 1. In the aforesaid factual background, this appeal has been filed. Learned counsel for the petitioner, learned counsel for the appellant submitted that the matter be referred for consideration before a full bench. On the other hand, learned counsel for respondent number 1 has supported the order passed by learned single judge. Paragraph. We have considered the submission made on both sides and have perused the record. Not there. Got it. Got it. So then, paragraph 5, right, of this judge. We have considered the submissions made on both sides and have perused the record. A division bench of this court. Para 4. No, para 5. A division bench of this. Chivanna and Schwartz. Right? M. Nagbhushan. Different. Then paragraph 6. Paragraph 6. Paragraph 6. In the instant case, preliminary notification under section 28(1) of the Act was issued on what date? Was issued on 7/5/2007, whereas a notification under section 28 within bracket 4 of the Act was issued on 24/4/2010. Stop. However, despite a lapse of 10 years, the board, the appellant has not passed an award. Full stop. Passed an award. Full stop. The learned single judge. Therefore, in the absence of any explanation for the delay in not filing the award and in not concluding the land acquisition proceeding, has rightly held that has rightly quashed the preliminary as well as final notification. Full stop. Paragraph. So far as the submission of learned counsel for the appellant with regard to reference of a matter to the full bench of this court is concerned, suffice it to say that on a query being made by the court, learned counsel for the appellant himself pleaded ignorance about the order of reference. Pleaded about the order of reference and has not produced the order of a division bench of this court, if any, making a reference to the full court. In the absence of any material, this court, in the absence of any order produced in this regard, it is not possible for this court to accede to the prayer of the appellant to make a reference to the make a reference of this appeal to a full bench. Paragraph. For the aforementioned reasons, we do not find any merit in this appeal. The same fails and is hereby dismissed. Interim order shall continue. The 24. Interim order shall, it has been admitted interim order. If any shall continue. Yes.
27.
Huh? Huh? Same view has been taken by division bench, right? Huh?
The additional documents are produced.
No. What happened to the division bench order? Learned single judges followed an order passed by a bench of this court in WA 3884 of 2019, 11/12. What happened to that order? Huh? So who will find out? No. I mean, when query being made, the court itself will ask you, then you will seek time. Why we should not dismiss it? That it is your duty to tell us that WA order has been set aside. Otherwise, we are bound. You are not telling same thing, right? They are casually telling that, just standing up. Why we should not? You go to Supreme Court if it is set aside. It's binding us. Yes.
So 171.
issue notice.
Please, Malaj.
Yes.
Malaj, I'm very sorry for my inadvertence in the morning, Malaj. Malaj, I'm very sorry. Malaj, I appear for the appellant.
Patient to a garden. So he wants an adjournment, some and substances, whatever is
Yes,
adjourned.
Malaj.
What do you
Malaj,
say?
the arguing counsel is due to a personal difficulty, not before Malaj.
Whatever. When do you want?
Malaj, any time convenient to this honorable court. Malaj, any time in January, Malaj.
Today is absolutely convenient. And seeing
Malaj,
the
any
bright
time in January.
sunshine, it's more convenient for us looking at the bright sunshine behind you and the greenery. It's very much convenient to hear the appeal right away.
Malaj, any time in January, Malaj, I would plead before Malaj.
So then don't say that any time convenient to us. Today is also
Please.
convenient.
Please, Malaj.
Question
Malaj,
of
any
your
time in January.
convenience, right? It's a question of your convenience.
Please, Malaj.
12th January. 12th December. He's saying January. He's appearing through VC. He can tell him what.
No, Lord, Lord, on behalf of the state.
Oh,
I'm sorry. I'm there, no, Lord. Sir.
Your junior is appearing.
No, Lord, no, Lord, I am appearing for the state, Lord, in this.
State. Oh.
Yes. No, I'm sorry, Lord, sir. I am constrained to appear.
I'm
constrained to appear through video conference because I'm not in.
All right. Yes.
No, Lord, I have no difficulty, Lord, except, Lord, there is one small ceremony which will be conducted on December 10th, which is that is a Dattamala program, which
yes.
Lord, I do not want tomorrow them to say that.
Oh, it matter.
Yes, that's the Peter. Yes.
Yes. Yes. Yes, lady lawyer was appearing.
Please, Malaj.
Sheila Gokhale was appearing.
Please,
yes.
Malaj. Malaj, it is on account of her personal difficulty that I am appearing before Malaj.
No, that's fine. But what about 12th December? Is Mr. Advocate General and this additional Advocate General are saying, then you will say that the
Malaj,
status has been altered.
Malaj, can it be after 15th December?
Yes, Mr.
No, Lord, there is no difficulty, Lord. Now, Lord, I will briefly bring to Lordship's notice within 1 minute what has happened. But pursuant to the order of the learned single,
You have constituted a committee. Last time you told us.
The committee has recommended, and now we have constituted a committee consisting of members of the Muslim community and a Hindu priest who will perform a joint puja for the affairs of this very unique kind of a worship place. That is the first aspect. Now, 10th, Lord, there is a Dattamala Abhiyan where they will go and worship the Padak of the Guru Dattatreya. I am bringing to Lordship's notice, but we will do that without disturbing the thing. Lordship may then hear the matter whenever it is convenient to my learned friend now.
Yes, Mr. They will be permitted to offer prayers on whatever and to do puja on 10th of December, right? And thereafter in January.
Malaj may then list it in the first week of December itself, Malaj.
Whatever it is, I'm there. See.
Malaj, 9th of December, Malaj.
Yes, Mr. Advocate General, 9th.
Yes, no difficulty.
All right.
Please, Malaj.
What's your name?
Kushal Chaudhary, Malaj.
Learned counsel for the appellant. Mark their presence, Mr. Learned Advocate General and Learned Additional Advocate General for respondents. Learned counsel for the appellant prays for adjournment on the ground that arguing counsel is not available on account of personal difficulty. List on 9th of December 2020.
Please, Malaj. I'm very grateful, Malaj.
12th is he has agreed for preponement only on that ground that you will do puja. 9th. So 9th he says. 6th, 7th, and 8th, Mr. is the puja.
Yes.
He was saying, you were saying, Mr. Nawadgi, 12th.
Yes. No, 10th was, I was informed. It could be 6. I'm sorry, bro. I thought it was 10. But
No, they are saying that it's 6th, 7th, and 8th.
then they are correct. No, they are correct.
Correct. All right. Yes, Mr. Then puja has to be done on 6th.
Malad, in such a scenario, Malad,
it would be
may
no
not be
prejudice.
possible.
It would be no prejudice to my learned friend, my lord. This is
No prejudice.
no prejudice.
Puja, every day puja is done. You don't probably, he may not be knowing about subject matter.
In
If
fact,
that be the case, Malad may then list it for post 15 December only, Malad. Then it was only on account of the 10 December information, Malad, that I was agreeing for 9. Malad, then keep it for 15.
So but they should be every day puja is performed as such, Mr. There is nothing new about it.
Yes.
Since your senior makes every time that they are altering status quo, that's why Advocate General has said.
Please, Malad.
It's performed every day.
Yes.
Every day, those people also, both people from both communities perform puja.
Yes.
There's nothing, whatever you offer prayers, these people perform puja. Everything is done like that. So it will be done.
Please,
there's nothing.
Please,
we will say so.
Please, Malad.
So which date? Now you tell a date of your convenience. We will
Malad, anytime after 15 December.
You tell us.
Malad, 17 December, Malad.
We have winter vacation.
Please, Malad, then perhaps, Malad, first week of January.
First week of January.
Very
good. What date, Mr. Advocate General? Yes, tell us an agreed date.
12 January.
12 January.
Yes.
12 January, Mr.
Please, Malad. 12 January, Malad.
All right. So, write his name, so and so, learned Advocate General, learned Additional Advocate General. Learned counsel prays for adjournment on the ground, right? That arguing counsel is not available on account of personal difficulty. Learned Advocate General submits that what Datta Jayanti celebrations shall be held on 6th, 7th, and 8th of December 2022, and the committee constituted by the state government.
Yes, madam.
Be permitted to perform the religious rites as well as puja. Paragraph in view of aforesaid submission, comma, it is directed that committee constituted by the state government as well as the devotees shall be permitted to perform puja in respect of Paduka of Lord Dattatreya. List on what date? 12th of January 2020. 23. Yes.
Obliged, Malad.
Appeal is accepted for hearing record. Interim order shall continue. He is also in Delhi, but not Karnataka Bhavan. Yes. Appeal is admitted for hearing record.
31.
Interim order to extend, my lord. Interim order has to be extended, my lord.
Which case?
29.
Extended, sir.
Yes, my lord.
Right, ask question to the court. This is the new form of video conferencing.
Sorry.
Yes. 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 Yeah. So, submission is no what I tried to near to intervene because I also produce number 31. Not to be really seen that was withdrawn, but it has become interesting. Well, that's not for indexing. They call it a
We pursue the matter, it will come again. So I will do this. Later I find that it. No parallel. No part of property was acquired by any authority, including any local authority. For the first time, my client purchased the property in fully converted property from the landowner. Prior to that, the PDA had sought for acquiring the properties on behalf of various property society. Thereafter, landowner gathered that matter on the Supreme Court that the PDA had no right to allotment. And now the landowners have written the money whatever they have received and the land certificate landowner. Thereafter, they got it from the non. And thereafter, the property has been sold. So, don't form either way. PDA or any local authority was taken on the forcibly and that the shape then any document show that or the PDA or any authority. The order and part of the authority the concerned land. Getting a retirement compensation to conduct the content. The authorities do not do the government. Clearly established that this land was in the road was PDA one month geography. It was returned as opposed to part of it. Some of it was important. The three issues were there are found in the PDA later and operating. And then also produced that it's not an RPA operation. Even the investment, all that, all the needs and gotten order, sorry, indication as the clear reference. It pertain on only page 1 in vernacular. It is very good example. Page number 35 of the market people and the clearly look at the road has been so the policy so
That's it. No. What happened? You have filed objections. What is this is to be heard? We'll hear it sometime, madam. Next week we will hear. Next week we will hear. Next week. Which date? Tell us. Except Monday, any other date. Except Monday. Except Monday, any other date of your choice. Tuesday. Oh. Tuesday is what date? 6th December. Petition is admitted for hearing. Let the same be listed for hearing on 6th of December 20. 1. 7th December. And then 1 minute, Mr. 31 you write. Heard, yes. 31. Heard on the question of admission. This petition has been filed seeking review of the order dated 27th October 2022 passed by this court in WA 1417/21. Paragraph after hearing learned counsel for the petitioner. We find that the order neither suffers from any jurisdictional infirmity nor any error apparent on the face of the record warranting interference of this court in exercise of review jurisdiction. Line 3. In the result, petition fails and is hereby dismissed.
First over matter, number 25.
We don't know. This is a password round. It can't be one more password. It's not a joke. This is not a joke, right? We don't want to start new practices in here merely because you start reading like you are expert in reading judgments. Order. Start reading the order passed by learned single judge. By that time, senior counsel will come. This system of communication is unique, right? The moment you will start reading the order, he will come. Tuesday. No. Tuesday we will take it up. Tuesday. We will say that in case he seeks adjournment, the interim order shall stand vacant. Oh, last time also. We can't help it. Oh, he will automatically come. No. It can't be passed over. You argue, Mr. Or we will adjourn and vacate the interim order. We can't do. 2811. 2811 order. That order is there. 27/6. Where is 2811? Any further adjournment is sought, interim order shall stand vacated. We will adjourn. When do you want? When do you want? Yes. When do you want? If we are granting, we are ready to grant you adjournment, Mr. Why should you take trouble? No, this is a password round. Mr. This is, what sort of a new tradition? Password round again, password. Then for everybody, we will have to, how many password rounds? Nothing. Learned counsel for the petitioner. The matter was called in first round. Thereupon Mr. Sarvana S appeared and sought a password. Again, the matter has been called in second round. Again, Mr. Sarvana seeks a password. since this is a passover, since the matter has been called in passover round, it is not possible to pass over the matter once again. This court on 28/11/2022 had directed that interim order shall continue only till next date of hearing, and in case any further adjournment is sought, the interim order shall stand vacated. Full stop. Learned counsel for the appellant at this stage prays for adjournment. Therefore, we have no option but to vacate the ad interim order. Accordingly, the ad interim order is vacated. When do you want now? Tell a date of your choice. What? Tomorrow? Is it next week? Any date? Not Monday, except Monday, any date. Tuesday. List on Tuesday. What date? 6th. What's so special about 6th December? Everybody auspicious day or allowing appeals or what? Do you know? Other case also she opted for 6th to 7th. So 6th and 7th are auspicious dates in the next week. Yes. But we could not have. Huh? Which case? 33. Huh? 2 weeks.
Already the interim order.
My lord, for the petitioner in this case, my lords.
Huh? Huh? Yes. Learned, how much time? Learned counsel for respondents pray for and are granted 3 weeks time to enable them to come, to enable them to file object. Interim order shall continue. Whatever we have said interim order, later on he should not say that please continue interim order. There is an interim order, mister. Whatever that interim order we have said will continue. So we are sure. See, he's appearing.
My lords, the interim order was applicable for last year, my lords, the last academic year.
So it is need not be continued.
It need not be continued.
I don't continue. 3 weeks. Fine. Yeah. 34. Mr. Ramesh filed objection. Government. Hearing for allowing writ petition. You should say it is fixed for allowing the writ petition. Why hearing? Who is appearing? Mr. For yes, objections you have to file. So his grievance is respond number 6 is less meritorious and he has been allotted seat in MD pediatrics. We have made his admission subject to result. So what is objections you have? So Mr. should file off. Don't want to file objection. When will you file? Yes. When will you file? We have granted you time. Which date? So subject to, but supposing if he succeeds, what can we do? Beyond the cutoff date, we cannot die. What is the last date, Mr. Ramesh? What do you think? Write it. This wherever it goes, it will go somewhere, right? Right. Fine. Right. Learned counsel for respondents. Pray for short accommodation to enable them to file objections. List on 1st of December 20. Second, first, no, second, or 2nd December. 2nd December. 2nd December. Yes.
35.
What happened yesterday? Not eligible. She had taken seat and surrendered. So therefore, she is not eligible. No, but which, I mean, she is an engineering student. But how Ayurveda? Engineering. Where is your statement of objection? Not there. Not there. That's why you shouldn't file in the court. Front there. Where is that information bulletin given? Clause 3 of information bulletin. Page. What's it? That's it. I felt like asking him. It's yours. Yes. What did you have to furnish details, right? I mean, at least. No, it doesn't say so, man. Doesn't say so that allotted this thing that admitted in any course shall not be entitled. It doesn't say so. Obtain the seat. Obtaining means allotment also. Mr. What? So what is I mean, what is she saying that she should be allowed to participate in the counseling? Ah. Ah. No, but you are as it is large number of vacancies are. I mean, you don't get it. Over. See. Kind of. Yes. In case you, without going into, you can, if you can permit. No, not a precedent. Not a precedent. It will not be treated as a precedent. You are not getting students for engineering courses. That's the impression we get. We don't know. No, it's like a BA degree, Mr. What are you talking? Engineering is a BA degree. Most of them are unemployed. B is like a BA degree nowadays. Most of them are unemployed. We will tell you for this thing, group 4, what is that called? Group 4? Group 4 post in the High Court. Most of them are engineering graduates. Most of them. They are all overqualified engineers working as domestic help. This is the standard. So, in everything, electronics, communication, engineering, civil engineering, we have all from all branches. So from there we have learned a lesson in life. From experience has taught us that we should never employ a person who is overqualified. This is all right. Find out. Yes. It's like that. All the engineers, they don't work. What happened? Got an order from Supreme Court staying. Have you filed reply to this contempt? File. What is it?
Why have you not complied?
No, don't give it to us. We are asking what is it? Definitely not in our names. So why are you giving it to us? So then, so it has to go there. Yes. So what is it? 1 lakh you have made payment. 1 lakh. How much have you paid? What is it? 1 lakh. Dated. This demand draft is dated today.
What is the date of the DD? Date of that demand draft?
Yesterday. 29. So what is the amount due, Mr.? Something means you have to tell us. 7 lakh. Thereafter, what is it? You tell us, at least there should be no dispute on that amount, how much is payable. I wait. No. Don't. Mr. Last time also we told you that we have already passed an order directing maintenance at a particular rate. Against that order, you have filed a special leave petition in which no interim order is granted. So therefore, by giving 1 lakh, you cannot argue all over again, and we cannot reduce. This is, you better let him go to the next court, so it's better. Ask him. He wants to. What is the total?
Now, according to you, what is the due amount?
6 lakhs. Maybe means what? What way maybe, Mr.? You don't know what we are asking you. What is, how much is it? 640.
You will adjourn it to next week. Both of you file a memo of calculation. You should also pay another sum of rupees 2 lakh next week.
No. No, everything. He has brought his, we told you he has brought his toothpaste, etc. with him. Toothbrush, etc. He has brought. We told you last date, right? He has no money, so let him go there. They will take care. He will be served with food, etc. Everything. If he doesn't have anything, let him be in jail for a while. It will be good for him. Change of environment also. No, we don't know, Mr. All. No. We don't know. An order has been passed, that is subject matter of challenge. No. No, we will send you to adjoining court. You will be all right. Fine. Since we are being nice to you, you don't understand, right? Fine. Which is, we will send it. Contempt. Which is this case, Mr.?
Separate list, sir.
Separate list. Separate list. Fine. Mark the presence along with the respondent present in person in compliance of the order dated 6/4/2022 passed by a bench of this court, the respondent has handed over a sum of rupees 1 lakh by way of demand draft dated 29/11/2022. However, the orders passed by this court have not been complied with. Let IA-1 of 2022 be listed for consideration before the bench dealing with contempt petitions. We don't know. We don't know.
Guys are leading the list from 2016 separately. The reason there may be a end for this.
We will decide their application. The court will decide their application for contempt. Thereafter, we will hear. Recovered. We will tell him today that we have sent one case for it.
Ready, man, he's on stage.
No.
He's ready.
This happens every day, Mr. One case we have vacated the interim order.
This is the practical.
Huh?
He's on stage again. Put on. I sent his colleague. Ready.
No, this is further hearing.
Not asking time.
No, please argue then.
Not
Not asking time. Very good.
Not
Go
asking
ahead.
time. Not asking time.
Argue. If you are not asking time, go argue.
He has introduced this argument. He is continuing. He's taking short accommodation. Not asking time.
Not asking, right?
No, never.
You understand?
And after that, my lord, this thing I have not asked him. I sent his colleague. He will be addressing.
Where is he?
He's report on number 1. You have to send his colleague also. I sent his colleague also.
No, we believe you. We have no reason to disbelieve you. But we are not approving of the conduct of your client in indulging in tactics. Sending every day one client, one advocate.
No, my lord. Your lordship will hurting my lord. I seek unconditional apology.
No.
It's not the way of my lord.
Don't seek. We have been nothing against you. We are talking about conduct of your client. Because of him only, you are behaving like this, right? One counsel comes every day.
No. Soon after he comes, the lordship will begin.
So it will be heard today,
Please.
Mr. Acharya. Come what may. It's very clear.
Soon after you must hear me.
We don't want to give an idea to your client that impression that he is above law. Nothing.
No such thing.
He has virtually concluded there's nothing. So it's a petition on the ground of.
Your lordship permission will begin.
Huh?
Yes, the lordship permission will begin. Yesterday, yes, you are going to complete.
That yes.
Please. Please.
Yes, madam, please wait. Let him come. Tactics, just taking a chance. But we will see to it. Mr. Acharya, 2:30. 2:30. Password.
Afternoon session, the arbitration part of that is taken.
No.
That is
They're not fair, Mr. Acharya. We told you. This is what.
I'm not escaping from the responsibility.
That's
He said that
no, you said arbitration matter.
No. Your lordship said that 2:30. 2:30. Again, I have to seek for once again password.
No password. No password. It will be 2:30. If you seek a password, it's closed.
Wait for morning committee.
Before 1:30.
Please, ma'am.
I'll
try to get.
Don't be under. Don't be under an impression that once it is passed over, it will not be called.
Certainly not. That is why it is great people like what you can look at my efforts.
No, whatever. We are telling you, don't be. Otherwise, you will disappear and say that it was passed over.
That's why I said
Mr. Raghavan will conclude within 15 minutes.
By the time I'll get in.
He won't take more than 15 minutes.
Please.
Because we believe he has a good case, therefore he will not take more than 15 minutes. So don't be under that he will argue for 1 hour and it will be 1:30.
Agarwal's client is very lucky present here.
You have engaged a counsel who is not present. What to do? So engage him, he will appear. Engage him. Yes.
Yes, please. They did not. What is the very simple way you want to put it? Yes. And therefore, what is that? I think has to be right now.
Mr. Vikram, is it correct? That now thereafter there is a judgment of Supreme Court. Oh, it's like the best thing is to cite your judgment and let Information Commission decide which one will apply. Yes. All right. Wait. Let's talk about. But give us some facts first time. You have not given a synopsis, so easier. Mr. Vikram. It's 1-5.
My notification is still order. So now we are now continuing with ABCD. And it includes any body controlled substantially finance. Non-government organizations. So when we that decision, we need to be on in. If it's subsidy. Loan. They get interest. Very amount. These are. I hope we take them. Back. You're not taking finance.
$53.
Second ball.
Please be kind to what we are doing. And then very sure here is the difficult part is the PIA is not ABC. There it only needs to be decided that it is a body owned, controlled, or substantially financed, or a non-government organization substantially financed. PIA is a company and ownership is very stable. In the two governments, they want stated the BIA is part of the statutory control 20 government holding the Airport Act and aircraft in the additional statement dated 7. Urban stated BIA is the statutory power. It is not stated article that over in dictated points, petitioner stated the BIA is the performing public and is performing public and statutory on the BIA other government it says control of BIA, especially in making matters, requiring people to judge. The petition is also having the control can be basically allowing this. Here one day indicated any resolution company that no change in configuration in association company can be brought about without the consent of government. The government would which considerably influences BIA government council has been certified delegate BIA critical emphasis the BIA and then it is state within the meaning of it. BIA has almost made initial time. 8 directors are 2 by airport and 2 by KSIDC. If the number of directors increases, the quorum for the board meeting will include at least 3 directors in private, 2 directors in state, and each of the board will be on simple majority. BIA and advanced following agreement with control. BIA is not a government entity. Management of BIA is vested in the board of directors, where directors representing private providers constitute CEO is nominated by private promoter. Then there are some judgments which I have in support of this intent, the BA is substantial. Substantially, state and central government state there is significant unqualified indirect. Is a loan which is prepaid according to the schedule 10 of the state supported bill. Contribution by way of equity and is only 434.94. The reference GA The loan of 350 crores is not given to consolidated CAG. CAG. Sorry, Siemens project that time. How trade holding all of them. Siemens project 130 projects. Zurich AG 55.5. LNG IDPL 55 points. Equity support CDE 326.7 and 80. Debt from government as per state support agreement 350. Debt from banks and financial is 1,108. Internal accrual 68. Debt and others is total of H, J and K 1,603.59. Total means of finance for the project. That is not the total of equity and debt is 1,950.29. Total funds for state promoters 410. So 22% of the finances comprising of equity and debt. According to this table, okay. Now, 23.1%, 350.7 crores made by equity, 350 crores by state support, 1,185.09 crores by debt from banks and finance institutions, and 68.50 crores by internal accruals deposits. In the above statement, PIR indicated government promoters have contributed 454.94 crores, being 22.53% of the subject cost, which is less than 50% total project cost, and therefore they cannot be set as finance projects essentially. It is clear from the law that private promoters with 200 crores being well for when you came up with the figure of 12.6, you omit the debt. This is what is being done by the commission. After taking the relevant argument, actually CG. The argument that the loan of 350 crores is not given to actually in fact, also a very connected this time. Their government SSA have only been done for ASFIC. According to Section 14 of the said Act, CAG can audit from the body authority if the grant or loan to a body authority is from the consolidated fund of India or a any state. And the amount of such of the total expenditure of that body authority. It definitely the commission. This provision may apply only to revenue grant, may or may not be connected to the present case. But with the previous approval of the president of the government, CAG can also audit the accounts of the body authority in consolidation of India or of any state in the financial year. He is not exempt of this 1 crore. Since this grant loan of 1 crore have been related to expenditure, it appears to us that such grant is either towards a capital expenditure. Since the contribution of the government to the project is much higher than 1 crore, Commission has no hesitation in putting the PAL is covered under the CAG Act. And CAG can audit from the PAL the previous approval of the president. As regards alternative criteria for determining the project, other cases suggest the substantially financial gain in the major part of one period is contributed. According to data, the major part of financing into private equity, debt from banks, and internal projects. The debts from bank and financial institutions cannot be construed as financing by promoters. That's not the question. The question is how much company goes towards the total financial outlay of the body in question. And that's how brought on to Supreme Court around it. Therefore, limited to equity the 12.5 crore project, much higher contribution being 22.93 to the project cost, and this is being government. Government promoters this involves not only their share cost, but also the debt under the SSA, because repayment of the state has subordinated repayment debt from banks and finance. Based on that, comparison of financing and then what the debt all debt marks, roughly 97, 40, 40, third point. Then 434 is the figure that comes to 22.53 crore because we have the taking now. And with all the debt that we borrowed from it has been argued that the state financial support of 350 crore is the debt which is to be repaid. The additional statement is explained. PIA stated government loan which is repayable not come within the ambit of funds. Also been argued. Public sector bank provides substantial financial limit for these arguments are not well conceived. To begin with, lending is the commercial activity of bank financial. They cover the risk, security, and six. They do not own the project. They are not owned, and those given by them PIA cannot be found to enter that's not it. Oh, yes. But the nature of state support don't be common. Being provided by the common support. It's not it's not to be this capital. It's not the modern kind of the repayment and the state support that is subordinate to the secured obligation. Then there are 69. From the foregoing, it is evident that even direct financing by government promoters is project is higher than financing by private promoters. If the indirect support which has been not being quantified is also taken in account, the government support will be much higher. Thus, it is evident that the financial support higher. We also find whatever criteria there are, there is no escaping the fact that BAL is substantially financed by the government. The project therefore satisfies both the criteria for having been financially substantially financed by the government, but the one laid down CAG Act and the one indirectly suggested by the Commission's finding is that BAL is partly owned, partly controlled. It is partly owned, partly controlled, but substantially financed by the government. The Commission has therefore no hesitation in holding that BAL, the public authority, as defined as a body substantially financed. Third, now, in the context of this order, now I want to go to state law and point out how criteria that has been laid down by the Honorable Supreme. Supreme declares for the law. That's not it. And if that criteria is adopted, which is the which I will speed. I'm willing to go through the entire of showing here option what and then satisfy your option. But one of the criteria which is question on the basis of the physical data and all those the first volume is not here. Can I tell you take 81 and 87? or compilation. First one, 17 you are taking pizza. Alcohol is for
27 is some other case, Board of Control for Cricket in India. Alvin?
The citation got is 2013 volume 16 SCC 82.
Yes.
But I know your office not straight away. You go to but you also can it to 6. But but the definition of public appearance. Right? The legislature is victim by defining the intended to embrace only both categories unless the context is. Section 2 gives the expression meaning and include. When a word is defined to mean something, the definition is prima facie restricted. Okay. What is the meaning of what is she in this case? The word substantially have been used in sections 2H, 2H, 1, 2. The expression substantially finance assets not being defined as substantial means in a substantial manner so as to be substantial. In Panzer versus Building, by interpreting the provisions of Section 10(1) of the Rent Insurance Act, the House of Lords held that substantial is not the same, it's not substantial. What's the importance? Substantial is not the same as not substantial. That is just enough to avoid the de minimis principle. The word substantial simply means solid, massive, etc. The legislature has used the positive and clear. You have substantial this is the test of it. Then what we see how they further deal with the word. So when the expression specific law, the substantial specific law, and explain the unique nature of law affecting the rights of parties. In Black's law dictionary, The word substantial is used as substantial of real worth and impact, considerable value belonging to a substance, actually existing, real, not seeming or imaginary, not illusive, solid, true, veritable, something worthwhile, not distinguished from something without value, a mere noun, synonymous with material. The word substantially has been defined to mean essentially without material quantification, in substance material. In short of Oxford English Dictionary, the word substantial means considerable amount of substance, sizable, very large, it's solid for value, real significance, solid, weighty, important, spread of an act, measure, etc. having force or effective force. The word substantially has been defined to mean substance and substantial thing. Synonymous with not in any topic. Nothing. Yeah, what? The word substantial is not synonymous with dominant authority. It is closer to material or important or considerable. Substantially is closer to essentially. Both words can signify very different. Then next two really provided subsidies, grants, exemptions, privileges, etc. Cannot be said to be providing funding to a substantial. Not so. Funding was so substantial, particularly municipal funding, but funding, it is so. Now, not there yet. The Bangalore would struggle and without a subsidy given by the government. Is mere grant of subsidy substantial financing? Merely giving a grant, an exemption, and a privilege. So, really providing subsidies and exemptions, just cannot be said to be providing funding to a substantial extent. Unless the first was the funding was so substantial on it, which particularly runs basis to it, and it would struggle to it. The state will also promote many schemes generally for the government and welfare of corporates. Therefore, my first submission to Lordship is the authority has not applied substantially laid down the number of if this because obviously the authority is significant of this definitely came out. Now let's see the body of the previous control essentially fine. Return to here are the view. I thought that complete over to the above measures. And gone to a intent to say the meaning and content to it the court has given a legal instruction to the expression public authority. Under section 2H of the Act, bearing in mind the transformation of law and the ultimate object is to achieve transparency, which according to the court to the own one objective. Also, RTA has help the protection The governing members, each body, to obtaining information with RTI Act, will be able to detect and prevent technology. Never knew. It is written in 2H of the Act, exhaust them there. Hence, there is no question of drafting in liberation to the to bring in other people to the court, which do not have its clearly. The court cannot, the rule is clear, about citizens, according to the court, we advance. You're also aware of the opening part of the definition law that says unless the context is no materials have been made available to show that the cooperative setting with which we are concerned in the context would fall within the definition in 2H. So that now this is all. So much of need all about it. But now we kind of see how if you want to kindly turn to page number 54. Around a approach which is the opposite of what Honorable Supreme Court says should be. Next, we have
What do you want? let us now consider. It is obvious that the section 2H is substantially financing the body when the ownership may not lie with the government. Not. Hence, clearly, the voting substantially should be company law, you significant to go to 26% that this would be taken to be defined would be subsidies in land or concession. Exactly what Honorable Supreme Court said, not conflict. Then, thus I am of the view, the petitions of the RTI Act are right. In as much as the petition say, indeed, another contingent was able to see some other can be imported in a particular act and that if the acts are incompatible with each other, then the definition of one act can be imported. In the case of audit, observe. You're watching the LCPs. Clearly, supposed to as observed, substantially finance is not declared in law. What would the phrase substantially has to be understood in contract restriction to the word previous. Where the funding is not clear to be ignored as pittance, the same would be substantial. Or the Supreme says
The contract. Substantial is not some small amount, it should be large amount of money, not trivial. Before now, therefore, it is substantial. It need not necessarily be cash flow, but any other kind, even this not is income. Supreme Court says any other is not in Karnataka versus. This come out. Please apply the law and don't. And if I am writing the submission, the principles laid down there and not be applied, in fact, contra principles are applied. Then you not be the case where it's a big case where you want to send it to the commission. And look at all the facts as of today. Determine with the permission of the law declared with honorable Supreme Court to find out that was. But if you are not actually on that point, you are not going to be taking it. If you are not no proceed and complete your submissions on every aspect of it, then we are not going to take care of the facts to show that the principles is not on the side. That is your I could only disagree insofar as submission. Supreme Court outright rejected all sorts of concessions insofar as land and all this. Supreme Court this is paragraph 48 of that judgment. Have the same compilation with
begins public authority. How does it? You are looking at your company. Is apart from it's para 48. Yes. Which?
So agreement is called the state support agreement. There is various actions that we do, including on state bank in form of very whether the state is giving DRS. What are reports around that person? Take into consideration. It's substance. I this aspect, I will be sorry. But we will already is keep the I research. It's very that there is substantial funding by support given by us. I think it's also creating extensions or other see whether this funding function because states. The ask this question of can function from states. See, this is going constructed for your passengers. There are explicit passengers. Without this, we have the entity of the on the part of this.
Ask him. He knows the answer. Only you can send otherwise the case worker. Let you keep it. With one case worker.
Lakshmi. Oh, Lakshmi.
Ah, yes.
My lord, for appearing for respondents in this matter, my lord, I make one submission, my lord. I have submitted a synopsis where there are two mistakes. My learned friend who is present in the court will correct, my lord.
You will correct, right? Please correct. You are ready, madam.
I am ready, my lord.
What is it? Huh? Huh? Huh?
The regulations are
will be provided.
all he can charges level again. One of the charges was subject matter of the criminal proceedings. Then this argument to help. The thinking of the disciplinary authority in having rejected from prayer for defense representation assistance by an advocate is not in accordance with the law declared by the therefore it will be reconsidered. In reconsideration, what they
So
did.
who said reconsider? This court said. This court.
Said.
Ah.
Instead of the order of the they did not go in appeal. While implementing the order, what they did, they rejected by prayer for defense representation by an advocate. On the count that we have no change in the presenting officer. Earlier, presenting officer was an ex-practicing advocate who was an officer. Your grievance was that he is an LLB and he had practiced law. Therefore, you should not have any grievance whom we have changed it. That aspect was not where I am facing parallel to things that were not true. That is considered by this court in Balasubramaniam. I brought the notice of the disciplinary authority. Then also, that rejection of the 3 days before immediately I obtained consent letter from one of the co-employees to defend me. And I faxed that request. You directly release the controlling authority of this officer to enable him attend the inquiry. This I sent on 23rd of July. Bank admits 24th of July. Bank admits that it received the request on Saturday afternoon. Monday was the inquiry. Therefore, we did not take any decision. In the result, the entire evidence of the management and entire recording of evidence happened on 4 days without any difference. This is one aspect, one issue that I have raised. Second issue is this. The Central Vigilance Commission, which held the inquiry, it recorded the finding that both the charges are not. Charges against me are not.
Who recorded the finding?
That is the inquiry officer who is an officer of the Central Vigilance Commission.
Yes.
He recorded the finding, charges are not. Then onwards, for about 1.5 years thereafter, bank did not take a decision on that end. Then there were series of exchanges. This is what I am expecting. That's what the client says. Series of correspondence between the CVC and the bank. And twice or thrice the CVC is stated to have advised them to accept the report and examine. But then also they issued a disagreement. They are entitled. I am not saying that CVC is advised binds or anything. That second show cause notice, when I am answering that disagreement. But a reading of the second show cause notice goes to show that disciplinary authority has conclusively decided against it. It cannot be said to be a notice at all. Then what the Supreme Court said in the Jonas Burgess case. Relying on that, I said, this is the conclusion. You have already come to a conclusion. But according to me, what the Supreme Court has said is that a proposition to disagree with reasons therefore has to be communicated. Then I should be given an opportunity to submit my report. He said you have disagreed, then you should. Then I also said, this is what transpired during the meeting I had with the then disciplinary authority and the chairman on such and such a day, which I have attended with prior permission. There, lot of things have happened between the CVC and the bank. Kindly make available to me that correspondence, because that is a part of the decision-making process. I am entitled to have looked at it and made this. That was not given. And the second show cause notice, in fact, at once between the second show cause notice and the final disciplinary addresses the communication. Your representation is untenable because I have power to disagree. All this before I could even submit my report to the second. There was one the disagreement procedure has been done contrary to principles of rights in as much as CVC the decision-making process, the exchange between the bank and the CVC has not been made. Second is the show cause notice itself was a concluded order. Therefore, it was a post-decisional hearing. Then I also raised one fact. The disciplinary authority, who is the respondent number 2 in the interview, the disciplinary authority. The entire thing started by a reply given by the disciplinary authority to the CBI, saying that these people have committed wrongs and all that, and that letter also I have placed on. And said that in the light of the fact that even before the disciplinary proceedings were initiated against, you have expressed a definite opinion on these matters, because you are from passing the final law. There was a change of the officers holding. That is not answered, and the same authority. Then there is another development which is again estimated. What happened is during the pendency of this appeal, the special court had formed a commission. But in respect of one charge which was the subject matter of the disciplinary proceedings has also been chosen. It exonerated the acquitted, but still conviction is there. And the conviction sentence has been stayed by the Supreme Court. It is pending. Therefore, this is the position. Now, what happens? By age of retirement is. You may also remand the matter because the defense I had to appear in the defense. Then now it has to start from that stage. It is my broad concept. I'll take my lot through the pages and in the course. These are all right. Some of the issues I have.
Yes.
I think I will argue the
Okay. Yes. We'll continue after the break. Mr. Ravi Shankar. After this case, Mr. Let. Yes, madam. Tomorrow, he says. Mr. D.R. Ravi Shankar, learned senior counsel for the.
You have been telling that you have not given the proposal. The matter is being urgent till tomorrow. Meanwhile, you can talk.
Mr. S.K. Acharya. S.K. Acharya, learned counsel for the applicant. Write her name. Learned counsel for senior counsel for applicant. prays for short accommodation and undertakes to argue the appeal tomorrow. The aforesaid undertaking is placed on record list tomorrow for further hearing. So what to do? There was an order. Please now. No, but the problem is that please move an application seeking interim relief. There is an order on a previous date. Your colleagues do not inform you what can be done. There is an order that if matter is not argued, it will be vacated. We passed, he said, first round, second round also, what to do? Make an application. Please make an application. Today we will consider what. Yes. Tomorrow. No adjournment. Why? Adjourn. Posted every day. It should not be posted, right? After 20 years, it should be posted, right? No, what is this every day? No, don't appear. No. If you are inconvenienced by the fact that it is posted every day, don't appear. Nobody. We will take care. So who prevents? Have we prevented you from filing citation? What does this mean? We want to understand that matter is being listed every day. What does it mean? No. Have it after 8 weeks. Who is in a hurry? Learned Council for parties jointly pray for adjournment. 42, right? List after 12 weeks. Right? We are not getting any increment in deciding your appeal, right? No. Not two. Why 2 days? Have 3 weeks. We have said still it's not sufficient. We will make it how many? 16 weeks. List after 16 weeks. Fine.
Court officer? Court officer? Court officer? Yes. He resigned. Which- He's doing 260. Oh. ಗೌಡ್ರೆ ಗೌಡ್ರೆ ಆಚೆ ಹೋಗಿ ನೀವು ಮಾತಾಡಬೇಡಿ, ಶಬ್ದ ಬರಬಾರ್ದು. ಕೋರ್ಟ್ ಬರುತ್ತೆ ಈಗ. எப்படி சென்ட்ரல் விஜிலன்ஸ் கமிஷன்ல இருக்கிறவனை ஈவோவா போட்டாய்மா, கமிஷனர் ஆஃப் டிபார்ட்மெண்டல் என்கொயரிஸ் அப்படின்னு. இன்னும் சத்தம் வரல இன்னும். வா வாங்கடா. அத்தாலேருந்து இன்னைக்கு கேப் இல்லப்பா, அவளுக்கும் கஷ்டம்தான். ஜட்ஜஸ் பண்ணாடு. ஜட்ஜஸ் வந்தா ஜட்ஜஸ் தெரியவா இல்லையா இங்க? அவ்வளவுதான். will allow, dismiss the writ petition. ஒண்ணுமே கேட்கலையே, பூமி கூப்பிடுங்க. அவர் என்ன ஆர்கியூ பண்றாருன்னு. ஏன்னா ஜட்ஜஸ் வரல, நின்று இருக்கார் ராஜ்கோபால். இன்னும் ஜட்ஜ் வரல, அப்படி இல்லை இப்படி எல்லாம் திரும்பி இருக்காரு. இப்படி எல்லாம் வருவாள் சீனியர் கவுன்சில். ஓஹோ, என்ன சொல்றான்னு ஒன்றும் புரியல. ஒண்ணும் பண்ணியாமா, என்ன பண்ண, மியூட்ல இருந்து எடுத்தான். எனக்குன்னு இப்படி ஆடுறது வேண்டாம். Right.
Oh, yes, Mr.
Shubhananti.
Some.
For the respondents, my lord. For the respondents.
Oh, we kept all of you waiting. Some urgent administrative work. Yes, yes.
My lord, sir, Mr. Senior Counsel, Mr. Rajgopal has to come.
1 minute.
Today, tomorrow they send all the.
1 minute, Mr. Rajgopal. One.
I'm sorry, quickly. Because tomorrow they send all the remaining seats will have to be repeated all. Before that. In order. Because after. So the rules.
Not entitled.
Judges வரல இங்க வரல ஸ்கிரீன்ல
Before that,
No. Now means today itself.
ஜட்ஜஸ் கூப்பிடுங்க ஒரு ஓட்ட கம்ப்யூட்டர் கொடுத்துட்டு போட்டா
From where? Then
Tomorrow morning you can come. Tomorrow you can permit.
Heard on the. There's so many vacant seats. That's why. That's why you are not getting applicants, candidates for those seats. Who knows? I mean, this will be pending. Heard on the question of interim relief. Please. Learned counsel for the petitioner submits that the petitioner had appeared in the CET examination 2020 and was allotted a seat in engineering discipline. Full stop. However, the petitioner could not take admission in the B course as the grandmother of the petitioner expired. Expired. Full stop. Expired. It is further submitted that the
judges வரல they have muted everyone.
We have muted everyone because we are dictating order. And you are talking to this thing, somebody, and disturbing us. Yes. Further submitted that bar contained under the commission will decide within 3 months.
It itself can be disposed of.
That the bar contained under the
Under bar contained under Rule 15(5) does not apply to the case of the petitioner, as the petitioner had not sought admission, was not admitted. Petitioner was not admitted to the seat which was allotted to him. Paragraph. On the other hand, it is also submitted that petitioner be permitted to participate in what round. Then that petitioner be permitted to choose the seat before the same is surrendered to the colleges. Paragraph. On the other hand, learned counsel for respondents submitted that as a special case, As a special case, comma, the petitioner be permitted to opt for a seat, paragraph, in view of aforesaid submissions. Paragraph in view of aforesaid submissions and taking into account the fact that the petitioner was not admitted petitioner was not admitted in the college in which he was allotted a seat, comma, it is directed that petitioner shall be permitted to opt the seat in the engineering course. Full stop, it is made clear that this order shall not be treated as precedent. Accordingly, line below, accordingly, the petition is disposed of. Yes. Signature. Yes. Sure. Based on the suspension, those dates I have been. Yes, yes, please. It is at page 190. Page 190. That's it. There are no charges. Paragraph of page 190. On 30th, on 31st October 91, you have declared an amount of 7.1 crore for an interest at 402. This was the same kind of notes in before the criminal case also. Criminal court also.
Yes.
In tab is at paragraph 3 of page 190. It is about acceptance of 3 bankers' receipts from the Fairhouse Financial Services. They say the charge is known last 8 lines. After obtention of these bankers' receipts, you should have informed your managing director, ABF President, that the outstanding is as on 30 with the constructive delivery of the securities. Backed by constructive delivery of securities. Going through this information, you are the then managing director, Vice Babu, representative to statutory auditor of ABF system that the outstanding were backed by constructive delivery of securities. Thus, the information you given by you resulted in misrepresentation. There are charges not about charge is about misrepresentation made by the managing director.
Yeah, at least been our
These were the 2 charges.
கேட்கல ஒண்ணுமே கேட்கல போன் பண்ணேன்
problem. Yes.
Lord, page 200 is the order of appointment of Commissioner of Department of Defense.
Mr. Movement is going on, please.
Madam, please don't make noise, madam.
Madam, you are live on the screen.
Please mute yourself, madam.
Inside the court. Can't speak like that. You are in the court. Conduct yourself.
Yes.
Sir, they appointed the presenting officer. The visiting cardinals I have kept at page 201. The law officer, the rank of deputy chief officer, MA. There was at page 202. I gave two circumstances seeking permission to be defended by.
So there's no difficulty, right? You should have been provided the assistance.
That
So
was rejected, then
when it was rejected, where is that?
Statement was at page 204.
Statement. Acha, it was set aside. Ah.
The rejection order. And then at page 9. It says not they are indulgent disciplinary contrary to the limits of the and directs the bank to reconcile the matter. If necessary, by giving him. On that basis, I made representation page 212. That was rejected on 19th May 1998. The document second page 21. I also got to notice of the disciplinary authority. Judgment rendered by this court in involves of commission. On the judgment, what are the substances the disciplinary authority may permit advocate defense depending on the facts. Therefore, this court wanted to lay down what are the general circumstances that therefore, the involves of where it is likely to result in dispute or where it is a criminal charge on the same aspect, it should be permitted. That also I brought to their notice. That is rejected now at page 216. Even without considering the test diagram by the court in the end part of the has been confirmed. Since we have decided that we have ended the presenting officer, you are not ended. Therefore, there is no. Then this was served on me on 23rd. Because though the letter is dated 2nd July, there was postal strike. 23rd July it was served. Inquiry was fixed for recording of evidence on 27th. 4 days and inquiry was I sent a fax message requesting the bank to permit me to be defended by a co-employee by name co-employee along with his consent letter that he is willing to defend me. That is admitted, Manoj, by the disciplinary authority in his order at page 482 is the order of dismissal that is imposed on me. In that order, at page 483. Because the page, Manoj, at page 483. Because the inquiry officer had commented in his report that in fact fax message was also sent and then to the head office of the phone also call was made to defense, but he was not given defense assistance. On that note, the disciplinary authority says at unnumbered paragraph 4 at page 483. On the comments of IO on the aspect of permission not being granted to you to engage the citizens of the Kalyan government as defense assistant. From the records, it is observed that your request dated 23/7/1998 seeking permission to avail the services of Kalyan government was received by us by fax in the afternoon on 25/7, a Saturday, when the inquiry was scheduled on Monday, because of which we were constrained in not granting and communicating necessary approval. Thereafter, the recording of evidence took place on 4 days. No permission was communicated. Therefore, all the 4 days, entire evidence was recorded without the assistance of a defense assistant. With the inquiry officer in this report states at page 402. Page 401 is the inquiry. Page 402, second line. Regular hearing was held on 27/7/1998, 28/7/1998, and from 26/8/1998 to 28/1998. During the regular hearing, CO was unable to obtain assistance of a defense assistant as no permission had been granted to the nominated defense assistant before me by his controlling officer. In doing so, controlling officer paid the operation of a David facing a Goliath who should have been provided every source. My first submission is this entire inquiry, because entire evidence was recorded without defense. Apart from my entitlement to be defended by an advocate on the test laid down in Baltimore. In CL Subramanian case, my lord is aware. Rule permitting to be defended by a co-employee has been held to be mandated. And there the inquiry findings were satisfied in CL Subramanian's case. only on the ground that such defense assistant was not permitted due to careless attitude of the inquiry officer in that case. Here it is careless attitude of the disciplinary. That is the only substitution I would make in CL submission. That is the thing. That is my first submission. The second ground is about the disagreement. Now on this aspect, what the London single did say, the interaction of only on one day the defense assistance could not be present. Therefore, no prejudice has been caused. Whereas the finding and recording, entire evidence against the PW1, PW2, PW3 was recorded in the absence of the defense assistance.
You have cross-examined them.
I have cross-examined. But the question is not when certain aspects are mandatory. Prejudice is not like
All right.
now, for example, in the matter of disagreement procedure, Supreme Court has said that the question of prejudice would not come here.
Yes.
Then these two areas where prejudice need not be.
Yes. Need not be.
Need not be. No, the inquiry officer gave a finding at page 414 because 401 the inquiry officer report starts. At page 414. He gave a finding that charges have not been proved. In spite of may not having there. But prejudice is caused after this. I had a proper defense assistant. Somewhat perhaps the occasion for the disagreement could have been avoided by a further proper cross-examination. On this note, at page 453, annexure MM. Is it supposed to be notice dated 13th? My reference submission, it is not a notice, it is a concluded order. First, the second applicability of the regulations cannot leave that segment. I am not proceeding. The inquiry officer gives a finding. Since I was working at that time in Andhra Bank Financial Services Limited, Andhra Bank conduct regulations do not apply. There is a finding given to the agency. There is a controversial area because a deputed officer ultimately has to be tried. He has to be tried under the working procedure of the deputed organization, but under the regulations of the parent organization. On that, I am not putting that point at all. But regarding the charges, what the disciplinary authority says, last 3 lines at page 450. With regard to charge 1, I observe that the IO concluded the charge is not true since funds have been deployed in the competent state and prosecution have not produced any reasonable evidence that the banker's receipt was not delivered to you. Assuming that the deployment history is that of the MD of the company, you should have concluded the transaction on 31/7/91 by taking delivery of the securities of the banker. The evidence produced during the inquiry clearly indicates that FGFSL, that is Fair Growth Financial Services Limited, did not deliver any banker's receipt or security receipt during the tenure of this transaction. I noticed that you have released the payment on 30 October 91 without taking delivery either of the physical securities or of banker's receipt. Accordingly, I disagree with the findings of the IO and hold the charges to the no evidence is referred. As a matter of fact, this is not traceable to any evidence. Only 18 documents were produced in the inquiry. PX1 to PX8. If he says more, which part of the evidence he is referring to, I can point out that a particular reading of the evidence is not correct, or there is no such evidence. And this is not, I propose to disagree also is not a statement. I disagree. Then with regard to charge 2, I observed that the witness of prosecution clearly stated that you had refused to accept 3 BR banker's receipt since they were dated 31/3/91 and written the same on 8/4/92. Further, the management's exhibit MEX 15 and 16 indicate that you have confirmed to the then MD of the company that the outstandings of Fair Growth Financial Services to the extent of 180.70 crore as on 31/3/92 were backed by constructive desire of the security in favor of Fair Growth Financial Services Limited. Accordingly, I disagree with the findings of the IO and hold that the charge has been made. This is also a concluded finding. Here only grace is that he refers to. Then I represent again the second the order of disagreement at page 455. In that note, I specifically refer to at page 460. I refer to the language deployed in the notice dated 13/6/2000, and I say that it is a concluded article. Therefore, it gives me really no opportunity. I also advert to Tulbe having that court said that how the disagreement has been. Then I refer to the evidence that has come out. And I say that, and the findings of the inquiry officer, and I say that at page 474, last paragraph, I say that the submission be accepted and I may acknowledge that if the district authority were to find that my submission did not find the I may have provided with the information material part in the earlier paragraph, and I be given an opportunity to get. The further material I had got in this regard is not the advices of the CVC issued from time to time, and the material basis for those advices, what the bank had represented and those things I wanted to have. The reply I get now is Annexure PP, page 475. Second paragraph is the substantial part. As a discipline authority, in terms of Andhra Bank Officer Employees Discipline and Appeal Regulations, I am having every right to agree or disagree with the findings of the officer, and my letter dated 13th June 2000 is pursuant to this power. I never questioned this power. He takes it as an authority. As if I am questioning the authority of the discipline. Then order is passed. Annexure TC at page 482. This is the order of penalty imposing the penalty. Page 483, Manoj. He admits that I was disabled from engaging defense of the point, like that paragraph of detail. I don't want to trouble the Lord with that. Then Manoj, regarding the disagreement, this discussion is from second paragraph 484. And they must have carefully examined various of your decisions. Page 485. First paragraph of that page. Last but one. In your submission, you have further stated that you will be able to of fact. Once we recover the entire correspondence, I only to state that the said correspondence is interdepartmental, and as per regulation, it has no relevance whatsoever to the charges or availing the. He declines. He rejects to give me the CVC advisors and the material of it well, saying that it is interdepartmental correspondence. Then, regarding your contention that we have already disagreed with the findings of the end, had you guilty even before giving you an opportunity. No useful purpose of this word by your petition to the court of outside is contrary to the principles of national justice. I have to state that in my communication seeking your submission, I have clearly and unambiguously given the reasons on the point where I am differing with the IVO's findings, and it is not correct on your part to say that it is no more than a. It doesn't say that it doesn't say that it is only a proposal. It was a wrong wording, but substance was it was only a proposal. Then he proceeds in that line, and at page 488, second paragraph. Your submission that the findings of the DA are not based on any evidence and is violative of regulation 7 of discipline regulations is not correct. As I have by disagreeing with the findings of the inquiry authority on both the charges, clearly spelled out the reasons for such disagreement and gave my own findings on such charges basing on the evidence produced in the inquiry. It is not dictated by bias or malafide or with a predetermination driven by inability to any of the questions raised by CBC as stated by you. No such questions. This is how much I have been from. Then now I came to Sample Court, then the Sample Court you exhaust the criteria in the appeal. I preferred an appeal. Then also that appeal was rejected by a non-considered order at page 556. I approached the then now that order at page 530. This another court set aside the order of the appellate authority for the reasons given at page 533. And then now the matter is remanded to the appellate. On demand, the appellate authority reconfirms the order. This is how I do it. No. Quickly. Regulation. page 1, these are the statutory regulations made in the longer than capital employees. Then now, regarding the difference of the assistance, it is regulation 7 of regulation 6 at page 6. Assistance of legal law is not engaging in legal practitioner for the purpose. Unless the presenting officer appointed the discipline authority is a legal practitioner, or the discipline authority in regard to the substance of the case. Definitely, these circumstances are developing. You know, developing. At the first instance, the bank thinks that the case is so complicated that it requires the assistance of a legally trained mind. Really, because it changes its presenting officer. And this more disabled disabled to take the assistance of a co-employee without permission of the discipline. So, originally, this note was not made. This note was intended. The officer employee will not take the assistance of the legal officer who are two pending disciplinary cases. That is the fact which has to be gone into by the discipline authority, and he has to give me. Then notes regarding disagreement procedure, there is nothing in this because regulation 7 within bracket 2. Issuance of notice and all was not there in this, but notice is judgment law under by Punjab. The disciplinary authority shall, if it disagrees with the findings of the inquiring authority on any article, record its reasons for such disagreement and record its own findings on such charge if the evidence on record is sufficient for it. I would lay emphasis on two things. One is notice, another is the inquiry officer, if he wants to hold me guilty, preponderance of probability. I am not I cannot and I am not disputing. But if a favorable finding of the inquiry officer is to be upset by the discipline authority, then regulation 7 sub-regulation 2 mandate sufficiency of evidence. The two tests are known, sir. Inquiry officer, after application of his mind, after having heard the and recorded evidence, if he wants to disagree, it is preponderance of probability. Statements I have referred to in the previous note. What statement my ballot I have? It will be paying for the court to go through full files. This morning I can start to. Not my kindly take the second judgment, which is at page 25. The judgment is confirmed by me, but I don't have a copy of it. Though I appear there was an unreported judgment of more than 25 years in case that. Paragraph 2 minutes. Okay. The text laid down in Venkateshwar Reddy are the extract. Just see there. If the presenting officer is legal practice for the personal legal training or experience, or if the charges are of a serious and complex, then note that paragraph 6, page 29. Sometimes the instant case is not in dispute that charges framed against him can and may not probably result in order of dismissal against him. It is also apparent from reading of the statute that allegations in the affair suggest criminal intent where after provision. After the case was presented before the later and so this test which I brought specifically, there is no application. Then as assistant by employee, allow me kindly take judgment number 6, which is the compilation, which is at page 67. Identical to not such in CCL and the track. Here that the accused not afford the opponent's facility to have the assistance of other government servants in defending in which assistance he was entitled to under the rule. He was deprived of that assistance solely because of the indifferent attitude adopted by the inquiry officer. Therefore, we have no hesitation in coming to the conclusion that the inquiry officers are clearly right. It is needless to say that Rule 15 is a mandate. The rule regulates the guarantee given to the government servants and article 311. Government servants by and large have no legal training. At any rate, it is this case that servant had legal training. Moreover, when the man is charged with breach of a rule and the entire he is not likely to be in a position in this case. At any rate, it is nobody's case the appellant had legal training. Moreover, when a man is charged with the breach of rules entailing serious consequences, he is not likely to be in a position to present his case as best as it should be. The accusation that the appellant pretend is very valuable. Any adverse verdict was bound to be disastrous to him, as it has proved to be. In such a situation, he cannot be expected to act calmly and with deliberate. That is why Rule 15.5 has provided for representation of government servants charged with the duty, their direction of duty, contravention of rules by another government servant, or an appropriate case by a legal practitioner. For reasons we think that there had been a contravention of Rule 15.5, we are also of the opinion the appellant had not been offered reasonable opportunity in himself. Then the infinite article. Therefore, I have to submit that the inquiry has to go and it has to go back to the stage at which they are providing. And the laws will not correct. Only difficulty in the laws. It is 20 years vintage, and now the difficulty would be none of my content are working. Therefore, to get a bank officer, and this bank has no margin with the union bank. All these then regarding the disagreement, I just point out one statement. Some thing on except reiterating or respecting all the earlier judges. That is, first, before that, my lord will kindly take Sri Malhotra, that is the judgment 5. This is the page 61. This is for the proposition of prejudice need not be. Para 14, para 19 of which we have in itself is extract, and it said the result of the above the discussion will be that the principle of practical of the regulation. As a result, they allow the authority disagrees with the inquiry authority and may not help. Then before it records its own findings of structure, it must record its tentative reasons for such disagreement and give to the delinquent officer an opportunity to represent before it records its findings. Then what's paragraph 15, 17 and all that. Paragraph 16, Yognath Bhagde all are referred. Paragraph 7, in Canada Bank, this deposit that this court 17. In Canada Bank, deposit this court explained the ratio of dignity in observing that it was the case where the disciplinary authority differed from the inquiry. In that context, it was felt that denial of opportunity of hearing was per se violative of nature. That's all I would like to do. What is the effect of post-decisional hearing? That is one of sir. My lord may kindly take HL Prehon, which is 201 judgment. 201. Paragraph 12. 200. It is however contended on behalf of Kunil that after the insurance circular was issued, an opportunity of hearing was given to the employees with regard to the alterations made in the conditions of their service to the insurance circular. In our opinion, the post-decisional opportunity of hearing does not fulfill the rules of natural justice. The authority who embarks upon a post-decisional hearing will naturally proceed with a closed mind, and there is hardly any chance of getting proper consideration and representation of such a post-decisional opportunity. In this connection, we may refer to a recent decision of the court in Shepherd versus Union of India. What happened in the case of the Hindustan Commercial Bank, Bank of Cochin, and Lakshmi Commercial Bank, which is private banks for amalgamated with Punjab National Bank, Canara Bank, and State Bank of India, respectively in terms of subject state government. The banking rate in this case requires the supplementary payback for employment. The services were not taken over by the respective transportation. Such distribution was made without giving the employees whose services were on offer from paying. Raghunath Mishra is speaking for the court. There is no point in having this position. The disagreement was to go, then our unconditioned they are raised in the state. Operator authority of state. That is not sir. Healthcare and not unfair trial followed by your parents. It does not you. That I have the statement number 13 I have referred to Institute of Chartered Accountants, page 159, paragraph 13, my lord. Is clearly said that we are entitled for where are 17, 8
No, not there.
Madam, Shubhananti, madam.
Yes, my lord.
Yes.
My lords, the first and primary contentions, my learned friend too, were regarding the appointment of presenting officer and also regarding not permitting defense representative. Whereas, my lords, I refer your lordship's attention to page 546, where, my lords, the appellate authority in his final order says, I do not find from records that Mr. G.D. Jayaprakash, who was initially appointed as presenting officer, was a practicing advocate before his joining the services of Andhra Bank. I find that from the record that he joined the service of the bank initially in clerical cadre on 26/1975 with a bachelor's degree in science. He acquired the bachelor's degree in laws academic from Kurukshetra University in May 1982, only after his joining the service of the bank, and that he was never a practicing advocate. Further, his stay in personnel department was for a very limited period from June 1993 to April 1995. Further, he was also changed as presenting officer, and in his place, Mr. P. Gopalakrishna, another officer in MMGS 2 cadre, was appointed as presenting officer. The charges alleged against you in the departmental charge sheet did not involve any complicated questions of law or fact requiring to permit you to have the assistance of a legal practitioner as your defense representative. Thus, the decision of the disciplinary authority in rejecting your request for providing the assistance of legal practitioner could not be faulted with. My lords, your lordship may see in page 216, the bank's reply, while rejecting his request, they say, we are in receipt of your letter dated 9/6/98 on the above subject. In your letter, you have raised several contentions which are not based on facts. It's not correct to say that the earlier presenting officer, Shri G.D. Jayaprakash, was changed with a view to deny the assistance of a legal practitioner to you in the inquiry. The fact is that G.D. Jayaprakash had resigned from the service of the bank, and as such, we have appointed another presenting officer in this case. So it was not with any mala fide intention, my lords. Therefore, the PO was not legally trained, hence the employee was also not permitted to have legally trained person to assist him. The other objection was regarding not permitting DR, that is covered in para 9 in the same page, my lord, 546. As regards your allegation that you were even deprived of the right to be defended by a co-officer, I find that your representation dated 23/7/98 seeking permission for availing the services of Mr. R. Kalyan Rao as your defense representative was received by the disciplinary authority only at 4:45 p.m. on 27/7/98, that is on the date on which the inquiry was scheduled at New Delhi. You were permitted by the disciplinary authority to have Mr. K. R. Kalyanaraman as your defense representative, subject to the fulfillment of the conditions laid down under Regulation 6(7) of ABOE regulations by DS letter dated 1/8/98. In spite of the permission accorded by the DA, you have not chosen to avail the services. It also does not appear that you have sought for adjournment of the inquiry till you receive the communication of the DA. On the other hand, on the advice of the inquiry officer, you have opted to alter the role of your proposed defense assistant to that of your defense witness. This your lordships may see in page 232. In his letter, he writes, however, in para 2, my lords, at page 232, this letter is 7/12/98. He says, however, in order to get on with the inquiry proceedings without any delay from my part, I decided to take only 2 witnesses instead of all the witnesses listed. Both of them were our own bank officers, and one among them, Mr. R. Kalyanaraman, who was also originally to represent me as the defense representative, for which role you have already permitted TADA as per rules, etc. Now, my lords, he himself has changed the role of his defense assistant to the role of witness. In that view of the matter, my lords, those submissions may not be correct, my lord. Regarding the disciplinary authority order, my lord, the lordship sees that at page 453, the disciplinary authority has passed an order, and last paragraph, my lord. With regard to charge 1, I observed that the IO concluded that the charge is not proved since funds have been deployed by the competent authority and prosecution have not produced any reasonable evidence that the banker's receipt was not delivered to you. Assuming that the deployment decision is that of the MD of the company, you should have concluded the transaction on 31/10/91 by taking delivery of the securities or the banker's receipts. The evidence produced during the inquiry clearly indicates that the FGFSL did not deliver any banker's receipts or security receipts during the tenure of this transaction. I noticed that you have released payments on 31/10/91 without taking delivery either of the physical securities or of banker's receipts. Accordingly, I disagree with the findings of IO and hold the charge is proved to this extent. With regard to charge 2, I observed that the witness of prosecution clearly stated that you had refused to accept three BRs since they were dated 31/3/91 and returned the same on 8/4/92. Further, the management's exhibits 15 and 16 indicate that you have confirmed to the MD of the company that the outstandings of FGFSL to the extent of 180.70 crores as on 31/3/92 were backed by constructive delivery of securities in favor of FGFSL. Accordingly, I disagree with the findings of the IO and hold that the charge as proved against you. You are advised to make your submissions, if any, on the above observation of the unders within 15 days from the date of receipt of this letter, failing which appropriate action will be taken on the basis of the relevant materials on your record. Now, my lords, he has referred to the evidence of the prosecution witness. Your lordships may kindly see in the learned single judge's order also that evidence is extracted, my lord, at page 92 of the paper book. She relies on the evidence of Sri R. Ganesh, chartered accountant, wherein he has stated as follows. Since no physical securities or bankers' receipts were available with FGFSL, and since Sri Lakshmi Narayanan did not want to turn down the request of Sri Sundar Babu, he told me to forge 3 bankers' receipts on the forged letterheads of the ANZ, Greenlace Bank, Bank of America, and PNB Capital Services Limited. The contents of these forged bankers' receipts were entered on the computer by Sri Ranganath on 8/4/92. While entering the particulars of the computer, Sri Ranganath erroneously entered the date of the BRs as 31/3/91 instead of 31/3/92. When the bankers' receipts are valid only for 3 months. These receipts were not at all valid. That is one of the important aspects, my lord. And then Sri Lakshmi Narayanan and myself did not notice this factual error. Sri Lakshmi Narayanan on 7/4/92 told to send the 3 BRs to 7/4/92, told to send the 3 BRs to Sri Tariam Chako and inform him, that is the appellant, my lords, and inform him that the banks on whose name the BRs were given to him owed the delivery of the respective securities mentioned on those BRs as FGFSL. Sri Lakshmi Narayanan further asked me to tell Tariam Chako that he has to return the BRs to us the day after returning a Xerox copy of the reference, since the bank receipts have to be discharged to the respective banks the next day of reversal for forward fees. I did as directed by Sri Lakshmi Narayanan. On 7/4/92, Sri Tariam Chako accepted the 3 BRs and returned the same to us on 8/4/92. Now, your lordships may kindly see page 197. In the reply of the appellant, my lord, to the charge sheet 197 para 3, my lords. He says, I have not accepted any banker's receipts as mentioned in the charge. Then, my lords, there is evidence to show that he informed the exhibits were produced in inquiry, my lord, PEX 15 and PES 16, which the disciplinary authority also has referred. PES 16 is a letter written by the appellant to the managing director, ABFS Limited, Hyderabad. Dear sir, statement as on 31/3/92. I enclose the following statements of contracts as on 31/3/92. Instead of 91, here he mentions 92. Then it contains one statement of ICD and funds accepted, original securities from corporate bodies outstanding with us. Two, statement of deployment of funds against RF deals. Please acknowledge. On basis of this letter, my lord, the managing director wrote to the auditors that the outstandings are backed by securities. That is PEX 15, my lords. That is in the letter to Brahmaya company, the managing director has written, we were holding investments to the tune of 128 crores 82 lakhs 37,913.36 paise as on 31/3/1992. Our Bombay office was holding investments of 62 crores 82 lakhs 37,913.36 paise, and our Bangalore office was holding investments of 66 crores. We have as of date disposed of majority of the above investments. Our Bombay branch is holding investments of so and so, and Bangalore office holding investments of so and so out of the investments as on 31/3/92. This letter was written by the managing director, my lord, based on his submission. And another exhibit, my lords, that is PEX 1, which the appellate authority has referred to in his letter, in his order. That is PEX 1 is referred while giving reasons. Here, my lord, page 544. Evidence brought on record concerning the charge of furnishing false information to MD of ABFSL. The letter dated 1/4/92 of ABFSL Bangalore PX 16, which is signed by you and addressed to the MD of ABFSL, enclosing a statement of contracts outstanding as on 31/3/92 PX1, shows that an amount of rupees 180.97 crores was deployed with the FGFSL, and that the same was outstanding as on that date. It is further evident from PEX1, which is a statement of ready forward contracts outstanding as on 31/3/92 with the FGFSL Bangalore. The 33 contracts were outstanding as on 31/3/92 with an amount of rupees 180.97 crores. This PX1 is signed by the appellant, my lords. And that document, my learned friend may be able to hand over to your lordships. An enlarged copy I have made of the document, wherein the appellant has signed the document showing that 180.so crores, my lords. Therefore, my lords, there is sufficient evidence on record to show that the appellant has misled the bank. Maybe no loss was caused, my lords, that should be submitted, but he had violated the procedures and exposed the bank to risk, huge financial risk, my lord. And regarding my learned friend's submission, my lord, that the disciplinary authority should give opportunity, etc. Here on 13/6/2000, the letter he has given reasons. He has mentioned exhibits 15 and 16. He has mentioned the evidence of Ganesh, which is extracted by the learner single jet. And then he has asked him to make his submissions. Therefore, fair opportunity was given to him. Now, my lords, my learned friend relied upon Punjab National Bank judgment. I have also produced judgments, my lords, on 2 dates. One is 27/7/21 and another is 26/7/22. In those judgments, my lord, I have referred to the case of Lab Nigam and the chairman and MD, ITA Limited and another, reported in 2007 1 LLJ, page 223. In this judgment, my lord, their lordships have considered the judgments referred to by my learned friend. That is in the list of judgments produced on 26/7/22, my lords. Page 223. That is the fourth judgment in the list, my lords. I have produced only five judgments. This is just before the last judgment. The lordships got it, my lord. There are 11 of the judgment, my lords. Fourth judgment produced in 22, my lords. That is 26/7/22. Can I read, my lords?
The citation, madam.
Citation is 2007 1 LLJ, page 223. Fourth judgment in the list, my lords, dated 26/7/22. Court officer will be pleased to assist.
Yes.
In this judgment, your lordships may refer to paragraph 11, my lords. In Punjab National Bank versus Kunj Bihari Mishra, AR 1998, Supreme Court 2713. That is the judgment referred by my learned friend also, my lord. A bench of this court considered Regulation 7.2 of the Punjab National Bank Officers, Employees, Discipline and Appeal Regulations 1977. The regulation itself did not provide for the giving of any notice before the disciplinary authority differed with the view of the inquiry officer. This court held at page 818 of LLJ. The result of the aforesaid discussion would be the principles of natural justice have to be read into Regulation 7.2. As a result thereof, whenever the disciplinary authority disagrees with the inquiry authority on any article of charge, then before it records its own findings on such charge, it must record its tentative reasons for such disagreement and give the delinquent officer an opportunity to represent before it records its findings. The report of the inquiry officer containing its findings will have to be conveyed, and the delinquent officer will have an opportunity to persuade the disciplinary authority to accept the favorable conclusion of the inquiry officer. The principles of natural justice, as we have already observed, require the authority which has to take a final decision and can impose a penalty to give an opportunity to the officer charged of misconduct to file a representation before the disciplinary authority records its findings on the charges framed against the officer. This view has been reiterated in Yoginath D. Badge versus State of Maharashtra, AR 1999, Supreme Court 3734. In this case, also Rule 9.2 of the Maharashtra Civil Services Discipline and Appeal Rules 1979 did not specifically provide for a disciplinary authority to give an opportunity of hearing to the delinquent officer before differing with the view of the inquiry officer. The court said, but the requirement of hearing in consonance with the principles of natural justice, even at that stage, has to be read into Rule 9.2, and it has to be held that before the disciplinary authority finally disagrees with the findings of the inquiring authority, it would give an opportunity of hearing to the delinquent officer so that he may have an opportunity to indicate that the findings recorded by the inquiry authority do not suffer from any error and that there was no occasion to take a different view. The disciplinary authority at the same time has to communicate to the delinquent officer the tentative reasons for disagreeing with the findings of the inquiring authority, so that the delinquent officer may further indicate that the reason on the basis of which the disciplinary authority proposes to disagree with the findings recorded by the inquiry authority are not germane, and the findings are not guilty already recorded by the inquiry authority was not liable to be interfered with. See also State Bank of India, K.P. Narayanan Kutty, etc. We have already quoted the extracts from the show cause notice issued by the disciplinary authority. It is clear that no notice at all was given before the disciplinary authority recorded its final conclusion. Here, the disciplinary authority has given an opportunity to make his submissions, my lord, in the letter dated 13/6/2000. Therefore, it cannot be, the procedure adopted by the disciplinary authority cannot be faulted. That is one aspect, my lords. Then, my lords, the other judgment, my learned friend cited several judgments regarding the denial of assistance of a legally trained person. My lord, I have relied upon the judgment of the Honorable Supreme Court in the case of Rajasthan Marudhara Grameen Bank versus Ramesh Chandra Meena. That is the third judgment in the same list, my lords. I'm sorry, my lords, it was not paginated due to paucity of time. The judgment starts, the citation is 2022 3 SCC page 44, and the relevant para is at page 53, para 16.4. Here, my lords, they refer to the judgment of the Supreme Court itself, previous judgments. In Crescent Dyes and Chemicals, it is observed and held that in departmental proceedings, right to be represented through counsel or agent can be restricted, controlled, or regulated by statute, rules, regulations, or standing orders. A delinquent has no right to be represented through counsel or agent unless the law specifically confers such a right. The requirement of rule of natural justice insofar as the delinquent's right of hearing is concerned cannot and does not extend to a right to be represented through counsel or agent. In the case before this court, the delinquent's right to representation was regulated by the standing orders, which permitted a clerk or a workman working with him in the same department to represent him. And said rights stood expanded, permitting representation through an officer, staff member, or a member of the union on being authorized by the state government, holding that the same is permissible and cannot be said to be in violation of principles of natural justice. It is observed that the object and purpose of such provision is to ensure that the domestic inquiry is completed with dispatch and is not prolonged endlessly. Secondly, when the person defending the delinquent is from the department or establishment in which delinquent is working, he would be well conversant with the working of the department and the relevant rules and would therefore be able to render satisfactory service to the delinquent, etc. Then, my lord, again at para 21, the lordships observe, page 54. As per the bank, there is a justification also to permit the delinquent officer to be represented in the departmental proceedings through serving official employee from the bank only. The bank has justified its action of not permitting ex-employee of the bank DR, and according to the bank, the ex-employee who themselves may have been subject of a disciplinary inquiry charge sheet, dismissed from service, the employee might be a part of vigilance or audit sections who come across a lot of information of confidential nature, and therefore if they are allowed to be DR in the departmental proceedings, which would result in grave injustice, the solemn nature of proceedings is taken away and would result in issues of orderliness as well as decorum when a disgruntled ex-employee is enabled to act as a defense representative. They may adopt delayed tactics in departmental inquiry and may not permit completion of departmental inquiry within 6 months as mandated by the CVC circular and as per vigilance handbook adopted by the bank. For all the aforesaid reasons, not permitting the delinquent officer to be represented through an ex-employee of the bank in the departmental inquiry cannot be said to be in any way in breach of principles of natural justice and or in violation or it violates any of the rights of the delinquent officer as per settled proposition of law and as observed herein above in decisions referred to herein above. The only requirement is that delinquent officer must be given fair opportunity to represent his case and that there is no absolute right in his favor to be represented through an agent of his choice. However, at the same time, if the charge is severe and of complex nature, then request to be represented through a counsel can be considered, keeping in mind Regulation 44 of the 2010 regulations. And if in a particular case, the same is denied, that can be a ground to challenge the ultimate outcome of the departmental inquiry. However, as a matter of right in each and every case, irrespective of whether charges are severe and of complex nature or not, the employee as a matter of right cannot pray that he may be permitted to be represented through an agent of his choice. Now, my lords, even the appellate authority has stated so in his order, final order, that the charges are not severe or complex and therefore there was no need for permitting the legally trained person to be to represent the employee. Regarding representation, Rule 6.7 regulation says the officer employee may take the assistance of any other officer employee but may not engage a legal practitioner for this purpose unless the presenting officer appointed by the disciplinary authority is a legal practitioner or the disciplinary authority having regard to the circumstance of the case so permits. So regulation also does not entitle representation by a counsel. Notwithstanding so many judgments, my lord, the 22 judgment in Rajasthan Marudhara clearly says fair opportunity to be given. Fair opportunity was given. He participated in the inquiry, admittedly cross-examined the witnesses, and most important aspect is, my lord, he was not prejudiced in any manner because the inquiry officer gave his findings in favor of the employee, notwithstanding whether documents were permitted or not. That is, the non-permission of the documents is discussed in very detail by the learned single judge in his order, my lords. Each and every document the learned single judge has dealt with and then said no prejudice is caused. And because the non-giving of documents did not prejudice him, because the findings were in his favor. So there is no need to find fault with the inquiry at all. In any event, my lords, the disciplinary authority has given opportunity. Personal hearing was also given to the employee. All his submissions were considered in detail by the appellate authority in his final order, which contains very detailed reasoning, my lords. He has extracted all the contentions of the employee from page 536 to 544. All the contentions have been extracted, and then he discusses each one of them. And in the light of the evidence brought on, record. All the submissions, one by one, are recorded from page 545 onwards. And therefore, my lords, no prejudice at all was caused. The differences arose because the disciplinary authority found in PX 15 and 16, the employee himself says he has securities, original securities. Whereas in page 197, in the reply to the charge sheet, I respectfully submit that he says he has not accepted any security. His own statements are contradictory. The employee has not come out with the truth. So these are all the aspects, my lords. Many of the judgments I have also cited and referred in my synopsis, and I have also opposed these contentions of my learned single friend as my lord senior counsel in detail. My lord, no adverse views against the employee were expressed by the disciplinary authority in page 480 to 81, which is only his reply to various queries put by the CBI. He does not in any of the paragraphs refer to the appellant or his conduct or about any of those aspects. And therefore, my lords, that is also not a correct ground, my lords. As I already submitted, my lord, denial of the documents did not prejudice him, and in the inquiry, he got a favorable finding. Then, my lord, the consultation with the CVC is in accordance with Regulation 19 of the banks, my lord, where they are asked to consult the CVC. Then, my lords, the other aspect my learned friend referred is page 480. Not 480, 480. Mr. Matthew from Central Vigilance Commission, he is appointed as Commissioner of Inquiries, my lord. And Matthew's appointment as inquiry officer was not opposed by the appellant in any manner at any time during the inquiry. And he has accepted, participated throughout, and got a favorable finding too, my lords. But for the disciplinary authority differing on the basis of other evidence appearing on record, that aspect was not considered by EO. The inquiry officer has gone on the basis, my lords, page 413, where he says that last few lines, my lords, these have not been produced by prosecution. We have instead claimed that PX1 was the enclosure. That is an assumption of on the part of the prosecution and not backed by any supporting evidence, etc. And then they say, I am much more struck by the time lag between PX 15 and 16 in the absence of any other correspondence between the two on the subject. I am inclined to conclude that managing director had not relied upon PX 16 or PX 1 to reach the conclusions expressed in PX 15. This is absolutely, actually, inquiry officer's reasoning is very, very weird, my lords. Whereas your lordships have seen that those documents, there is no time log, because one document, that is MEX 16 is 1492, and the other is June 15th, 1992, 15. These are invented reasons by the inquiry officer, my lords. If I am permitted to say so, sorry, my lord. So, in that we have the matter, my lord. And one more aspect is, my lords, he has drawn subsistence allowance till his dismissal, date of his dismissal. And the other aspect is, my lord, his date of superannuation according to bank is 30/10/2010, my lords. Your lordships may kindly see page 161, where the affidavit of the inquiry appellant also says that in 2009 his age was 59 years. Therefore, 2019 may not be correct date of superannuation, my lord. That is one submission. And no adjournment or no request was made that criminal charges are pending, therefore inquiry should not proceed. That kind of any request was not made by the appellant. Having regard to all these aspects, my lord, and having regard to the risk to which bank was exposed and the violation of all the regulations and the forging of the bankers' receipts, and knowing that they are expired receipts, he has accepted them and exposed the bank to risk, my lord. That is all my submission. Synopsis I have produced.
Yes. Judgment number 7 at page 7. It is as observed in December. Maybe then the decision advice from CVC, but it was not part of the decision making process. What was not made available to the respondent, it is difficult to rule out the apprehension about the decision having been taken there is nothing that can say will be highly explainable. On the other hand, it said at paragraph 30, that was the case where no paragraph 30. It is an empty formality going to the notions of matter industry and not substantial. And the other contention about Rajasthan will different. All that is said in paragraph 10.5 and 17 is that right to representation depends upon the standing orders or regulations in court. And it cannot be dealt for ex-employee or retired employee. All that it is said that it is governed by the regulations. That is what has been recorded at paragraph 17 and 16.6. Sir, there is no judgment to say that what is permissible under the regulations. Then here also they said where there are things under the charge is severe, you have to permit. Thank you. Compromise. When will you appear? Huh? Next month? 7th December? The net council for the parties jointly submit that there is a possibility of amicable settlement of the dispute. They undertake to appear before the Bangalore Mediation Center on 7th of December 2022. In view of opponent's submission, hearing is deferred. No, it's not being taken up right away. Huh? These cases will be repeated tomorrow. Huh? Remaining all cases tomorrow. No, no, we will see tomorrow what. Why? Huh? 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 One appeal. Ah. There is no interim order, right, madam? Next week. Huh? No, next week, madam. This is first or second week of January. Why? Senior counsel is not available till then. We are sure Advocate General is also required there in border dispute. Learned Advocate General is also required. So, what additional document? Huh? We know something about the case. Also, you. Yes. Next week, any date, madam, of your choice. Will not adjourn it beyond vacation. Which case? 54. Learned Senior Learned Counsel for the appellant. Mark the presence Learned Counsel for the appellant. Press for adjournment on the ground that arguing counsel is not available. List one. What date, madam? 7th or 8th? 8th December 20. No chance tomorrow. It's not a this thing that when the case is listed at 5 o'clock, you will, what you have been doing, you yourself are an advocate. Don't worry, we will help ourselves. We will appoint an amicus curiae to assist ourselves. Don't worry.